Hypocrisy.
Hey, what's up, guys? Welcome to Law-splaining, or late-splaining, the interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. How's it going, guys? How are you? Sorry I wasn't here today to stream. It was my kids have a play tomorrow. Today was their dress rehearsal. I had to help out a little bit with some tasks, so I wasn't really able to stream during the day. So here we are. A little later than planned, but today was too much of a firecracker to not deal with it. We got to talk about it. We have to see what the hell happened. I assume you guys know, so I assume this isn't a big spoiler for you. The defense and the prosecution rested. So it's over. Like, I mean, not quite. They have to do jury instructions and closing arguments. And why is my hair so poofy? They have jury instructions and closing arguments. Unreal. The defense presents no defense at all. It's going to be, it's going to be, we're going to talk about it. Yeah. All right. So first thing we're going to do is finish day 12. There's just a little bit of day 12 testimony left from the lead detective, the lead narcotics detective, who has been absolutely devastating to the defense. He's introduced the most critical evidence. They saved him for last, and it's over. It's over. I mean, my opinion, this bitch is guilty as hell. I think the state has. I'll carefully word this in a minute. When we talk about it. But Miss Jessica, the kids did great. We haven't seen any of their stuff. Like, they'll occasionally sing a song or two from the show, but this is the first time I got to watch most of the show. I had to run an errand and stuff like that, but I got to watch most of the show, and it was pretty cool. So it's going to be a great show tomorrow. But we'll see. That's for me and the family. Let's see a couple things real quick. I ran into this group of lunatics online who are like way into the Kyle Rittenhouse trial, but like in a negative way, and something about Racine, Wisconsin. Like, and they're like, you don't know about Racine? Why didn't you cover it? What are you hiding? Are you on the payroll? I'm like, yeah, you're normal. You guys are great. Wow. All right. But I don't know. Like, I don't care. I was just like, they got mad at me for saying something. And I was like, well, all right. And then they're like, you don't even know about Racine. Allie Clavin on Twitter. Allie, get off of Twitter and get on to YouTube. She says, how are you wearing a suit this late into the night? Lol, get some PJs on. These are my PJs. Just kidding. Okay. All right. So we're going to finish up this catastrophe here. Let me get the stream converted, transed over. Locals, come on. You know, like, be helpful today. Be helpful. And last couple things, of course, I guess I should pin the super chat links or the super tip links. We do have super tips available. Again, we freshly resupplied. The truck came in today, and there are plenty of those at supertip.gg/RL. Feel free to use them all you want. There are more on the way. What else do we? You can, of course, use super chats, and you can use Rumble rants. Those are all exceedingly appreciated. Exceedingly appreciated. If you hate all those options, there's also, like, I don't focus on these things. There's also the Rumble wallet you can use, and there's Coffee, which is ko-fi.com. Ricada Law at all of these places, any place and every place. There's also Cash App and Venmo and PayPal. It's all Ricada, like at Ricada Law. It's all there. It gets really tiring, like not tiring to me, but it's really tedious to like rehash those same things over and over and over. Crow's Milk says Nick is a wardrobe god. I like it. I like it. What else do we have? We've gone back to the 80s, that entire color scheme. Yeah, I feel like an 80s newscaster. I saw the tie, the sort of like light, it's like a tannish brown suit, a little more brown than whatever, our shirt, and then the jacket. The Goodwill jacket, baby. So here we go. Let's do it. Let's do it. I don't know how long this show is going to go tonight. Hopefully we can get through everything. We'll skip all the breaks and irrelevant stuff. But thank you, Azel, for that. We'll skip all that irrelevant stuff, and we will, we'll just hit the trial. And I'm going to hit you with love and affection. All right, here we go. Here we go. This is where we left off. Couple minutes left in the cross-examination of the detective.
Okay.
I'm going to go back for that, though. I want to hear what her question was.
Objection, Your Honor, relevance.
Follicle.
They then met a probable cause standard for the arrest of Miss Richins.
Okay.
We gave that information to the prosecutors, and they filed.
Oh, and of course, put those members in the stream. Put those members in the stream. I want to see you guys abusing your free monthly membership chats. I want to see as many reds as possible. I want to get you non-communists over into locals as well. We did put the locals chat up on screen recently so that people can kind of see what shenanigans go on over there. And they are unacceptable. They're unacceptable shenanigans, but they are fun. And you're welcome to go join them. I hope you do. So here we go. Adding the super tip link. And I do want to say specifically thank you guys. I did something the other day that I don't like doing, which was I needed a new computer. I'm waiting on a couple things coming, I think tomorrow, some mounting stuff, so I can use it a little bit more effectively in a dock and stuff like that. But it might be over the weekend. Either way, it's almost ready. It's almost ready to go. I asked for help purchasing that, and I hate doing that. But you guys came through most of the way. I went ahead and made the purchase early because I didn't want them to go back out of stock and stuff. But you guys have really helped out with that. Thank you so much. It was time, and hopefully I can eliminate some of the little jitters that do exist as we get things transitioned over. All right, here we go. This is the lead narcotics investigator in the Kouri Richins case. He's the guy who introduced her children's book. He's the guy who introduced the journal. I think it's called the Yellow Journal. And he's also the guy who introduced the most devastating evidence for Kouri Richins, which is the walk the dog letter. And here we go.
Charges in this case. They then requested an arrest warrant be issued from 3rd District Court. I executed that warrant by arresting Ms. Richins.
Have you ever heard of hair follicle testing?
I think I've heard that term.
Oh, let me get this out of the way. Yes, I know about the Ralph stuff that's been going on. I'm gonna say this because people are gonna ask me. I don't give a fuck about what Ralph is doing or anybody else. I'm just over here streaming a trial. So if you want my comment out of it, you're not going to get anything, like a no comment. I don't care. I don't have any interest in getting involved in that sector of the internet. We're here to talk about a trial, law stuff, have some laughs. Y'all are welcome to laugh or seethe or whatever you want about anybody involved. Just don't ask me about it because I'm not interested. So with that, here we go.
I don't know what you're referring to.
What's your knowledge of it?
That people much smarter than me can
I'm not
test
really
hair
an Erica Kirk
follicles
fan.
for what it can tell you about the body's biology. About the
Specifically,
extent of what I know.
isn't it fair? You've been a narcotics officer for a long time.
Objection, Your Honor, relevant scope.
This is beyond the scope,
Your Honor, it goes to the investigation or lack thereof.
but beyond the scope of the version.
lack thereof.
Or the version of.
I love it. I love this. She is so bold in some of the things she says. The lack thereof. This investigation uncovered the drug mule, the drug dealer, a letter involving a plot to generate what appears to be a fictitious story to plant the idea of an alibi on the evidence. It uncovered a very strange journal. It uncovered this children's book and the text messages from it. Like, well, the investigation or the lack thereof. This investigation was so thorough, they had to call a plumbing company to ask for a title. They didn't investigate the irrelevant stuff that Nestor wanted them to. Good night, Cookie. Have a wonderful, wonderful rest, and may you dream of so many beautiful, white, pink-tipped, tall members. Because I know they're your favorite.
Direct examination regarding the investigation. You have other options to get into this. It's just not right now.
Okay.
Hell yeah, Aunt Clara.
Court's
Welcome.
indulgence for just a
Welcome.
moment, Your Honor.
Of course.
I'm looking like Matt Murdock because I can't see my own problems. I like this from Ben Dustin. Get your super tips in early. Also get them in often. Repeat offenders are exactly what we like. And speaking of that, I think he was telling me something.
Spoilers, I thought that Kouri's guilty plea came out of left field. Psych! Bet she has a micro-peen. I think the defense needs to focus more on the government conspiracy against the black man.
I agree. I agree 100%. That's what the government needs to do. We did get a micro-peen there. We may have some locals members. We definitely don't have a cock and bull mention yet. Okay, here we go.
When you searched Carmen's house, did you test any pills that were found in Carmen's house?
I don't remember. That would be a better question for Miss Gibson. She handled all the evidence recovered from that search.
You were
Too bad you
aware
forgot to
through your
ask.
investigation that shortly before Eric's death, he was on a hunting trip in Mexico. Is that right?
Yes.
And the very last thing Eric ever did that we can
Speaking of pain management, Aussie Overlord. Managing the pain. Managing the pain of still having to pretend that his homeland of Australia is a real place.
establish
What's up,
before he
brother?
passed away was a Google search, right?
Hey, what's up,
I don't know
Chichunia?
if that's an accurate statement, but I know
Chichunia,
that
3 months a member, and I almost did it. I almost did it. You tell me if you want me to do it. I almost did it on instinct. But good to see you tonight. Always a pleasure. Oh my goodness.
a Google search was found on Eric's phone the night he died. That was, I think it was searching directions or how far it was from Utah to
Utah.
Sonora, Mexico, I think.
Right.
Like
And
if
did
you
you,
had to drive, how long it would take to drive.
okay. And did you do any investigation into where Eric went hunting when he was on his hunting trip in Mexico? Where was it?
Yeah, I don't remember the name of the outfitter. Todd Rice was the contact that we had with the hunting outfit in Mexico.
But I mean, where in Mexico? Was
I
it the
don't-
Sonora area?
I think so.
Okay. Also, according to Ms. Lauber,
Real quick, Aussie here says, I legit have no idea. I haven't seen any of this. All right, let me give you a brief rundown. This chick in the ugly shirt over here, who looks like she just never left that shirt or never took that shirt off after a quinceañera. She is not Latina. She's a culture thief. She is accused of murdering her husband by lacing his Moscow Mule with fentanyl, a whole lot of it. This guy over here is Ramos. This is Wendy Lewis. She's lead counsel. And this is, I don't know her name, her first name, but her last name is Nestor, and she is lead BMI counsel. They are appointed attorneys, public defenders in the state of Utah. Like, not from the public defender's office. They have a private law firm, but they take appointed cases and have for quite a long time. They have done a terrible job of defending her. The state, their case is being prosecuted by this guy. His name is literally Bloodsworth, and he is a vampire who talks like this. And he has been meticulously putting together a case with no direct physical evidence, with low credibility critical witnesses, built entirely on circumstantial evidence. And guess what? Despite that descriptor, I think he's kicking ass. The rest of the state's counsel is a girl who looks like she's 14 or 15 years old and it's like stole her dad's suit and faked her identity because like her parents got kidnapped in Bermuda and her babysitter, abandoned her in the middle of the country in Utah, and she had to fake a job like in Don't Tell Mom the Babysitter's Dead, but more Mormon than that. So she actually has 2 or 3 husbands already. That's what she looks like. I don't know. That's the description I got from the New York Times. She has been completely mediocre and effectively pointless. She's just someone to ask questions while the other guy's on break. But he has put together a case where literally has built I believe, a beyond a reasonable doubt prosecution without direct evidence of any kind, only circumstantial.
she estimated that each time she got pills that apparently she says she gave to Kouri, they were 15 to 30 pills per transaction. Is that accurate?
Her statements.
Your Honor, the foundation is to when, during interview, during testimony, during when?
Just provide a little more foundation for the question, or a little more detail for the basis of the question.
What is your understanding of how many pills were involved in each transaction that ultimately allegedly went to Kouri?
Approximate, well, total or each time?
Each time.
Each time approximately 15 to 30.
Oh yes, and Aussie, this defense team will be the appointed counsel, or is the appointed counsel for Tyler Robinson, the alleged murderer of Charlie Kirk. But we all know Charlie Kirk was killed by usury. And definitely not Candace Owens.
Right. And that would be a total, again, math, but if you have 30 pills times 4, that's 120 pills.
TBRHT, not a
That
chance.
half maths for me.
And you were in the courtroom when well, strike that. Did you give Carmen rides to meetings with her attorney in your
This is all
car
I needed in my life, Mighty Bob.
after she agreed to cooperate with you?
We helped transport Carmen when she couldn't get somewhere. It wasn't usually in my car. It was in Detective Maynard's, but yeah.
How often did you guys give Carmen rides places?
It was only a couple times.
Did you talk to her on the phone?
Yeah.
Check in with her? Went
Look
by
at
and
her in
saw
the
her at her
shower.
house?
We need answers to each.
I'm
Oh,
sorry.
You gotta say yes, because they can't type, mm-hmm.
Right.
Whoa,
so what
watch,
is the
hold
answer?
on, watch me, bitch. I can type Why are they defective in Utah?
To the last question about you called her on the phone,
Yes.
you would go by and see her in person?
Well, not just like to see her, but like if we needed to get in contact with her in person for some reason, yeah, sometimes we would go to her house.
This has been Nestor's cross-examination strategy the whole time. She is like trying to imply impropriety, but she knows she can't. She knows this guy didn't go like over there to pound one out. Like, she knows that, but she wants to try and get the jury on board with that. It's just not. It doesn't seem to work.
To her work wherever she was at.
And this relationship or these interactions that you had with her extended from the time she agreed to cooperate with you to literally she showed up in court, right?
If you're referring to myself and Detective Maynard, yes, because Detective Maynard contacts and deals with Carmen a lot more than I do.
Okay.
Whoa. Constock, we don't talk about physical appearances here.
Getting close, I'm sorry. Thank you for your patience.
This is the end of
okay.
yesterday, so.
I want to talk about the, Lord, if they're GIFs or GIFs, I don't know, but GIFs that have come
GIFs or
in,
peanut
those
butter?
pictures of the goofy pictures that they said that Kouri accessed the morning of the 4th, right?
I'm sorry, who's they?
All right, I'll be more specific.
Yeah, that would be a
The
good
GIFs,
idea.
you saw them come up on the screen. They were like joke GIFs, right? That it was testified to that Kouri's phone accessed them all at the same time the morning of March 4th, the morning Eric died, right?
What I understand about the gifts is that there were, I think, 3 different ones.
Yes, we'll be switching to
And
today's in just a minute. There's
that-
just a couple minutes left.
They were somehow accessed on Kouri's device. The technical jargon of the digital forensics is whatever Mr. Cochradimos testified to.
I'm with you on that.
I don't
So
remember,
clearly,
so him.
I would imagine, as the lead investigator, if you're investigating a potential homicide, would it be important to you to look at the very last conversations that the decedent and the suspect had right before the death?
It could be part of it.
Did you do that?
I believe I did. I don't remember what the contents were, but
Katie, can you please pull up JO11? JO11?
What's the
And
JO
this is only
stand for?
Yeah, okay.
I have my ideas.
And make it a little bit bigger so that Mr.
Keep JOing, you
the
might make it
Detective
bigger.
O'Driscoll can see it clearly.
Also, just as a general trigger warning to whoever may join, this show is not like the other law shows or trial watch shows that you see. I make dirty, offensive jokes, and I like it. And if you don't, good. Go away. Don't bitch at me. No one is right now, but you will eventually. But like, this chat is about like, yes, discussing what's on the screen, what's going on in the trial, asking questions, talking about law, but it's also about life, and life requires levity, and levity does not arrive with a sanitized approach to discussion. Enjoy yourselves within the level of your own dignity, which I hope is low.
And take your time looking at this, and I'm going to ask you some questions about it.
Damn it. Chuck Morris, I'm still a lawyer. I'm just suspended. If I wasn't a lawyer, I couldn't be suspended by the Lawyer's Office of Professional Responsibility. But you're right, I can't give you legal advice, and I don't want to.
Do you recognize these texts? Keep going, Katie.
I recognize that they are from Eric's device, yeah.
All right,
Gosh,
and they're between whom?
I enjoy explaining some things like that. It makes me feel good.
Eric Richins and Kouri Richins.
And what is the date, sir?
I saw Chris
Can you
Bookhammer.
blow them up, please?
Short answer, she's thinking about what
Sorry.
the answer to that
March
question
3rd,
is.
2022.
This is the day, literally, his last day on Earth. And it's the conversation.
Yeah. So she and I need to do two things. One, she needs to decide the answer to the question. Two, I have to verify that that's something. I have to verify how we can have that. Like, because if I'm disallowed from possessing that, I don't think I am. But for example, if I were, we need to determine an alternate way for her to store it until she was able to use it, like where I won't have access and won't be in possession of it. And so I just got to work with the people involved to make sure that everything's copacetic with that.
Yeah, with his wife, right?
Wow, that's what it looks like.
All right.
But I have to
And-
look at all the timestamps to
And
give
certainly-
accurate context for
This
that.
entire
I'm
stream
really sorry, I didn't
is
mean to
legal
interrupt you.
advice. I am all of
Certainly
your lawyers.
you reviewed
and
this
the,
as part of your
Minnesota
investigation.
Ethics Board wants me to say that. They want me to let
probably.
you know.
I'm not
This is all
remembering
privileged
them,
too.
but-
So tell me all your
Your Honor,
secrets.
this,
I have not
You have
looked
to
at
send it-
every single text message on.
You have to send your secrets by super chat in public for them to be privileged. That's kind of the secret way that I'm a lawyer now. I'm not allowed to say that in private.
Eric's phone and on Kouri's phone.
sure, but like the day he died would be in a kind of an important day to check out, right?
Yeah.
Okay,
I'm
so
gonna-
do you
Like
recall?
I said, that's
I'm gonna
that's
out
where we
SEO
got
the
the
Beatles.
information about the hunting guide in
Okay.
Mexico. So yeah, we were looking at that information.
So then, Your Honor, may I please admit this as Defense Exhibit 300, I don't even know what we're on yet. 3010. Is it 10? It's 3015. We're a little behind. Thank you,
Holy
Ms. Brittany, I
buckets.
appreciate that. We move to admit it.
Objection, foundation, or authenticity. I'm also looking at maybe approach.
Yeah.
Yeah.
Can we go to is this the first page, Katie?
Okay, so here's another thing I've been working on, and this is kind of just a test run for future cases. I've been having ChatGPT build a trial binder. Trial binder, when it's done, again, this is, for this case, we're coming to the end of it, so it'll mostly be for whatever. This is going to go to, I'll be making it available for paid members. And it just has as many publicly available documents as I can get organized into categories. It'll be in one zip file Then there's like a CSV index file to help you know where everything is. And you'll be able to grab these from either the members community tab on YouTube or locals. And you can grab any of the filings that I can get a hold of in this case. And like I said, they'll be organized out. You can download the whole zip file. I don't care. It's all public stuff. But I'm just compiling that because one of the things that's been lacking in my trial coverage personally is having these documents available. So I wanted to start developing a format, how I utilize AI to go grab those things, because sometimes each state has its own system for grabbing documents, and Utah is harder. I can't get all of them because the documents themselves, like each one of them costs money, and most of them are irrelevant. But there's like over 1,000 docket entries, for example. But
We do not have time for both defense and
there are some filings that are really important. I want to make sure and have those. In other cases, it might be easier to get all of them. The main problem with them costing money is it takes away AI's ability to go do it for me. Like
Let's pause there.
I could go do it document by document, but that takes time, and I don't know if I'm going to get around to it on this case. But I want to have that ready for the next case so that we have a public trial binder that people can go to and update. And maybe we'll crowdsource the documents, in those things where people can add to them, or certain people can add to them if they want to help curate in future cases. But I am building that out. I'm going to put that up available as soon as I can figure out the best way to do it and let you guys know where that is. But these are the things that I'm trying to build in. Like I said, I've been gone for 2 years, and I come back and nobody does trial streaming differently. They just do it. Everybody just does it alone, which is fucking boring. And so trying to find ways to add value and make the thing better. I should have had 2 years, and I kind of stopped trial streaming since 2022 because I just didn't have as much time. I've missed out on 3.5 years of making trial streaming better than it already was. And I'm sorry. I'm sorry I left you with people who didn't. Some people did. Some people do their own things, whatever. But I checked around and I was bored, and I actually did kill myself multiple times. And I had Eric Richins' EMTs bring me back with their chest compression machine. But as I was checking out other people's content, I thought it was really just subpar. It's become like a boring money grab, and that's funny, but it's embarrassing. So I'm working on stuff to make it better.
There will likely be
You guys help me out
additional
with that all the
questioning of Detective O'Driscoll tomorrow morning from both defense and the state. That additional questioning we do not have time for today. So,
Treasure Island, I need a name. Who was that? That will teach you to not pay your co-host. Yeah, okay. Having already discussed that plenty of times, the amount of money that each of those people got in exposure is off the charts. It's really funny, and most of them were very happy about it. But yeah, it's not just me. Everybody wants to stream alone because everybody thinks that they're gonna rake in money like Rittenhouse and stuff like that. They're not. They should come up with other arrangements. Figure something out. I was shooting from the hip. But people can build better systems. But everybody doing it alone isn't working. It isn't. And it wasn't working for Karen Reed either. You do have a couple individual lawyers really cleaning up or whatever. But a lot of the magic happened because of the dynamics of having the lawyers discussing things between each other live. That really sold it during Rittenhouse and Depp. And that's gone. And so it needs to be either replaced or it needs to be repaired. Cup of Sooth says, hey, Nick, it's Rico. It's never RICO unless it's your uncle. Tanner Smith says, you probably talked about this, but do we know yet if Charlie Kirk killer trial will be televised? And if it is, will you cover it? If it is, I will 100% cover it. That'll be a huge trial. And I do believe the current thought is that it will be televised. I can't think of any reason it wouldn't be. It's the same defense counsel here. So we know it's not against the rules in Utah to have a murder trial televised. And I'm not aware of anything particularly sensitive that would preclude them from doing so.
We'll be recessing for the day between now and tomorrow morning at 8:30 a.m. As always, please don't talk about the case with anyone. Please do not allow anyone to talk about it with you. Please do not read, watch, or listen to any coverage of the case. Please do not do any research about the case. Please travel safe.
All rise, covered.
We already did the fashion review for this day. We're not going to do it again.
No, Your Honor.
Ms. Nestor.
No, Your Honor.
Okay.
Detective, I need you to be back here at 8:30
So
tomorrow
detective is coming back for redirect. Cross-examination, I believe, is done, or they're going to continue cross and then do redirect for day 13. We will move to day 13 now, which is today. He said I was unable to be there. I have heard about some of the things that happened, and I am very, very excited to see what we get here. Okay, let me... Yes, Sandy Michel. These are Tyler Robinson's public defenders currently. Treasure Island. Okay, who is the name? Can you DM it to me? When you said that there wasn't even, the law tuber wasn't even there, no commentary, like, I need to know. I need to know. All right, so this is only 4.5 hours. I say only. We will be skipping breaks, so I don't think this is going to take 4.5 hours, but we'll see. I've got some time with you guys. Fudbusters is good, but I only really watch him when he's collaborating with guys I already watch. I love that guy. He's hilarious. I need to talk to him again sometime soon. Oh, it was potentially criminal. Wow. How embarrassing. How embarrassing. I will say, during the Karen Reed trial, I had to do that a couple times because I had to drive my kids a couple places. I don't know that he has like if he had I don't think if they can achieve escape velocity. So I think they just stay inside of him if he does have kids, but I don't think he does. So, doesn't have the same types of issues all the time. But I know he does. I mean, he does actively practice. So maybe he had a hearing or something. Ryan Snerdley, no, it's just timing. We'll get to it. I started it. I didn't feel the vibe at the time. Like, it's very interesting. I just didn't feel the vibe at the time, and I need to get, like, the timing just needs to change for me, if that makes sense. All right, let's do this. How am I boomering hard tonight? Here we go. Should be right.
Coming in. Well, that as part of it.
Guys, and let's just take a pause. What the fuck? What the fuck are they thinking? This is the worst outfit she's had yet. Yellow? No. Yellow under gray. No, no, no. Awful, awful collar line. Like, I don't know if she bought the wrong size or if she just had some sort of barbarian make that with a carpet knife and a seal. Like, what the fuck outfit is this? This has been a problem for her the entire time. But as we know, since she's not going to mount a defense, it doesn't matter. It doesn't matter. She chose to lose. Chose to lose this case today. Oh, this is horrible, though. Awful outfit.
Well, that photograph is already in
You know what,
as
Chichunia?
part of Exhibit 340.
I was going to
Which
advertise
It's
for
not
you,
in,
and
but
I'm
we've
not.
stipulated.
We've
No, I'm
stipulated
not.
is
I'm
coming
mad at you.
in
You hurt my
next.
feelings.
But I just want to show it's the same picture. That's it.
I can put that tie on right now.
And forgive me, you're referring to an exhibit that hasn't yet come in
We've stipulated to it. It's about to come in.
through.
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
What,
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see, Your Honor, I still think there's a hearsay problem. Based on counsel's explanation now, I also think there's a relevancy
son.
objection. The photo that we've been discussing.
I'm just kidding. I would
The
never do
gravel
that without
photo.
your
The
consent.
gravel photo
Guys,
was not accessed
Chichunia
at
runs a
8:39.
sandwich
It was
shop.
accessed at 10:42.
Well, this is
In my
a
mind.
foundation question.
That's what she
but
does, and I'm advertising for it.
The premise of the question Ms. Nestor is seeking to ask is, was this photo among the communications
It was
or
not
sent
Hmong, it was
by
Cambodian.
Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Constock, you
Full stop.
passed the test.
I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I think publication's the hearsay. The fact that any photo was sent is fine. I think if we get into the specific photo that was
I agree,
sent,
Fletcher boy.
there's a hearsay problem.
Are you taking the position that the photo is a statement?
Thank you for
Yes.
the super chat.
I'm not sure that follows without additional context. Just sending the photo it's evidence, it's a fact. I'm not sure it's a statement.
The statement is, I just dropped gravel at the Midway Mansion.
Well, I don't think any of that's coming in. It's just the photograph.
But that's what the photograph says.
I don't understand. Is there text on the photograph?
No, Your Honor, but the defense has, the defense is, as part of their case, said that Eric Richins was into the Midway Mansion as evidenced by him dropping
I want to come back to what I understand is being proposed by Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with
DJ
Kouri
Moore,
Richins the day before he died?
do it in the
yes
daylight.
or no? I understand the answer to be yes. Did he?
I like the judge. Like, I know this is silly because the judge is wearing a robe, but the judge has typically worn that tie with a white shirt, and I actually like the blue, the sky blue here. I think it's nice. I think it brings out his baritone voice, and it also brings out erections across the country, but mostly in my office.
He send Kouri Richins a photograph as part of those text messages on March 3rd? Yes or no? Yes. Is this the photograph that he sent? Full stop.
I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh, no,
an
fair
option.
enough. I'm not telling you how to testify. And I
Thank
don't
you.
know
I'm
what
as
to say.
tired.
But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine. Then we don't have a foundation
is
problem.
on
We don't
my
have a
side.
statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand Do we have a common understanding of the limits of what you can ask Detective
Absolutely.
O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't, it's too hard for him to, I mean, I think it needs
You
to
can't
be.
show the text messages without provoking the hearsay problem.
No, not to the jury, just to refresh.
Oh,
Real Patriot Party says, Ricada Law, can we post bail for the gun and get him on here to share some opinions on defense tactics? I'm not talking about a situation. He's out. He doesn't need to have bail posted or whatever. I don't know the details around that. I don't care. People are doing their own thing, and I'm happy that they are. You guys are welcome to talk about it, but I'm not making any comment on it, and have no interest in tracking down that story. Seems like those people have their hands full, and they can stay that way on their own. Here we go. I need to get my Rumble rant window up. There we are. Okay, here we go.
Because I think it's got to be, he's not going to know, it's just going to be a weird picture.
understood.
Should we just go
Are
ahead
you
and?
going to publish the photo to the jury, though?
No.
Oh,
I hate you guys.
So
I hate you.
we could just go ahead and admit 340 now, because then the next question is going to be, is this the same photo that is in this picture right here? And then we're done. Is this the same photo?
Wildling
this is not a
Sama,
question
better
for, me,
for
it's a
grooming
question
you.
for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now, there's the follow-on. Is this the same photo? That is akin to publishing the photo that brings up the hearsay problem.
You've made a record regarding the state's position that the photograph by itself is a statement subject to the hearsay rule. I'm not persuaded.
Okay.
And so, however, I don't know that just admitting 340 without providing the jury any testimony to provide foundation for context is going to be helpful.
I'll do
so
it.
is
I'll
somebody
do it.
going to tell them what 340 is?
I'll do it through him. I'll just do it through him.
Okay.
That's fine. We do have one other, if we're resolved with this. I think we're all clear. I know what I can ask and what I can't. I think we're fine.
Okay.
There's another issue. May I bring it up?
Please.
All right. I really need Officer O'Driscoll to leave the courtroom when we talk about this, because it's
Oh.
about specific questions.
No problem. Detective, if
Well,
you,
why are you asking
take
the
a
judge like he said no
step into the
earlier?
lobby, please don't talk to anybody while you're out there, sir. Thank you.
Okay. Thank you, Your Honor. I'm doing this out of an abundance of caution.
You do
to
everything in
avoid
abundance.
any potential.
You put the bun in abundance, you big bitch. Oh, you're awful. You didn't represent your client at all. I mean, I know she's so guilty, but God, you guys suck. Ew. Terrible. I'm angry. I'm viscerally mad about how bad the defense was this entire time. And I'm sitting there thinking, like, well, maybe they're going to come in and they've got a good strategy. They've got some good witnesses to come up with. No, they're going with the fucking law school bar exam question defense, which is, oh, we just won't levy a defense and we'll highlight to the jury how the state hasn't made its case. But the jury's going to be sitting there given jury instructions to say that all of these things have been entered into evidence, and now they have to decide if they've been sufficiently discussed. Like, they're cooked. The jury is going to be subtly instructed that there is evidence of all of the elements of every criminal claim, because all of those claims will still exist through the judgment, the directed verdict that they're going to ask for at the end of the state's case. They're going to ask for a directed verdict on all of those things, and then the judge is going to say, no, you're not getting your directed verdict, which means that sufficient evidence, at least legally, has been admitted into the record. Now, it's up to the jury to determine the sufficiency of that evidence weighed against any contravailing evidence to see if they knock out any of the elements of any of the criminal acts. But the jury is going to be told that it's all there if they look for it. You'll see if you believe, right? And they're going to be like, well, the state didn't do enough. And the jury's going to be sitting there going like, no, I know exactly what happened. And you haven't told me what didn't happen. You're done. Again, this is a legal theory type of defense. It has happened before and it has worked because sometimes the state doesn't make their case. It happened in a case in Minnesota. I think it was, a case from a guy who lived in Minnesota. His name is Howard Root. He wrote a book about it called Cardiac Arrest. Ran a medical devices company, was charged by federal agents down in Texas, even though he's from Minnesota and the company's up in Minnesota, and the sales rep who is implicated the company was in Colorado. That doesn't matter. They had a judge in Texas who finds everybody guilty. And ultimately, the defense did the stand up and said, we rest, Your Honor. We have no witnesses. We have nothing to present. The state has not done its job. They sat down and they did win. They did win. It happens. But if you want to read more about it, Howard Root wrote the book, Cardiac Arrest. It's all about it. Fascinating story. Really cool. So not nerdy and boring and dry. Go look it up on your own. But it's not going to work here because the state painted a plenty adequate picture of how this chick hired her housekeeper, who is a drug addict, to go talk to another drug addict who sold drugs, to buy drugs, to bring back, to leave in a house that she would then go pick up, that she paid for with a check. All of this is done by text message. And then she would then dump that fentanyl in the drink. The only thing we don't have is someone watching her put it in the drink, because the only two people who saw it or who could have seen it were her and dead guy. That's it. So yeah, they don't have physical evidence of it. They don't need it because what's the other outcome? They're toast.
I'm trying to be very careful to comply with the court's ruling on the motion in limine not the motion in limine. The motion to admit the statements of David Norris.
No, K-Star alert. Maybe she can wear yellow somewhere else. It's not spring. She's not out in the sun. That yellow shirt is being worn in the winter indoors. It doesn't contrast her skin color enough. It really doesn't go with the jacket. It's not a good court shirt. It's sort of loud, but it's also boring. And the cut is awful. The collar, that collar is probably longer than Joshua Grossman's penis. Like, what the fuck? Like, how wide are those collar lips? A neck labia. Honest Doubter says, so you're saying it was Halderson's girlfriend? Yes. She done did it. She did eat it and she bit it, and you know it.
So
Not.
correct. Our motion to admit that was denied.
Yes.
So just to
I don't care what the
make
weather's
the
like in
record,
Utah. I'm talking about Minnesota. That's where the weather is.
defense sought in advance to get approval or actually we gave notice to the state that we intended to call a witness named Mr. Norris, who
Chuck Norris
would testify if called, that on an occasion in 2019, I believe, in 2019, he had an encounter with Eric Richins where Eric Richins asked him if he had any fentanyl.
Oh, okay.
He had corroboration for the interaction, not the statement, but the interaction with Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
Or for Kouri, but.
Correct. The court the reason we were trying to introduce that statement, we were trying to get it through the catch-all exception to hearsay.
The residual.
The residual, I'm sorry, I call it catch-all, same thing. The residual exception to the hearsay rule, which requires a head notice, which we did give. The state objected to that coming in. The court ruled upon it, did the analysis under the residual exception, and made a finding that the defense could not call Mr. Norris to the stand to testify because the residual hearsay exception requirements were not met. It is my desire with this witness to ask him the following 4 questions about his investigation. And it touches on Mr. Norris's
Naval, I'll get you in a
testimony,
minute.
but it's a separate matter. But I just, out of abundance of caution, I am
Good night, Windy
giving
City
you a
DJ.
heads up. So the first question is this. You discussed with Mr. Bloodworth yesterday that the way you approached this investigation was to look for evidence based on 3 possible scenarios: an accidental overdose, a suicide, or a murder, correct? Question number 2. And in order to properly investigate whether there was an accidental overdose, certainly any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Pause there for 1 second. I got it right.
I'm sorry, I do have these if you want me to
Correct.
email them to you.
No, it's okay. Just
Okay.
give me a moment.
No worries.
Was it prior allegations that Eric?
Any allegations that Eric had a prior history
Good logic has raided the stream. What is up, my homie, my brother, my... Oh, like I say like tongue-in-cheek Jew stuff to Joe all the time, and like sometimes I feel like I'm overdoing it because I like get comedically lazy, and so I'm gonna see something non-Jew related to him. What up, ho? I love you. You're my man. I loved talking to you the other day. I was really glad to reconnect in the most gay way in public. Let's do it again really, really soon. Thanks for rating my channel all the time. All the time. And welcome to Joe's viewers, of course. Let's hit this super chat real quick. I was gonna get for you, but Naval Brick Company says, have a panel interview tomorrow for judicial courtroom assistant. Any advice? All right. No, I don't have any advice that is like tried and true here, but I'll give you my thoughts. I'll give you my thoughts really quick. I don't know anything about the judge that you're interviewing. Like, I assume you're going to be interviewing for a judge. You said judicial, what was it? Judicial courtroom assistant. So that's good. Judges believe in the system that they're in. They believe in the sanctity of their courtrooms. They believe in the force of their orders that they have been duly entrusted by the citizenry. Judges, I think of all politicians or political figures or government workers, I think they hold the highest regard for the lofty ideals that America was built on. If you're in America, if you're somewhere else, just go the corruption route and bribe someone. But if you're in America, just go in there, say, look, I love justice. I love advancing the cause of justice. I want to put my skills to use doing that in a meaningful way in an environment where I can further not just a sense of community, a sense of healing, and a sense of completeness, but I can further my own education. I can further my own understanding of the origins and the future of this country, and I can build a level, an empathy and a respect for the rights and responsibilities of every single person in my community. And then I can take that knowledge at some point in the future and I can go out and advance the cause of justice in my own way. Just be honest with them, but play to those sensibilities. You take those words and polish them up. Take what you know about your own community and focus on that. But hit those ideals. Judges live in ideals. They issue orders that change people's lives based on those ideals. They care about them. Focus on that. But do it honestly. Don't like ham it up. Don't lie. I think that's a pretty, and if I'm wrong about why you're getting into being a legal assistant in a courtroom, you know, like if I'm wrong about that, obviously scrap what I just said. But that's a pretty specific job. Sassy J in the UK, speaking of advancing the causes of justice, has brought 5 beautiful members to the chat. It just dropped them all over you guys. Oh my gosh, your foreheads are probably bruised at this point. Thank you, Sassy J. You've actually kicked us off on memberships tonight, and I really appreciate that. You guys are welcome to drop as many more of those as you want.
Of seeking fentanyl would be potentially relevant and important to look into,
Currently,
correct?
want a job. Yeah, there you go.
Got it.
And with, this is the
You're
next
going
question.
for a law degree.
Within the past few months,
You're going to live out the ideals that you learn in that courtroom. You want to learn them from a good community with a solid foundation and a respect for the rights of its people. That's a good speech.
did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about about an incident where Eric allegedly asked someone for fentanyl? Want me to read?
I don't get this. They have not let Eric's statements into this trial at all, which I disagree with. But if they were to let these statements elicit this type of hearsay testimony from Eric, but Eric's an unavailable witness because he's dead, so that shouldn't be a problem. But whatever reason, they're not letting the Eric's statements in the entire trial. If they were to let him in on this, it'd be really gay. I don't think they do.
That again.
Sure.
And within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl? And then there's one more question. Let me know when you're ready.
Let's be real. How big an asshole was Eric? He doesn't seem. We didn't get any testimony like that.
Sheriff investigative team. Give me the last clause one more time.
Who wanted to share with the investigative team information about an incident where Eric
Reese Kane.
allegedly asked someone for fentanyl.
When you're going to play strip poker with the chat, always wear 2 ties. Because that's one more loss you can sustain.
Okay.
And the final question is, did you or anyone else connected to the investigative team ever sit down with this individual and talk to them? Did you make any efforts to see if this individual was credible or had corroborating evidence to back up their claims? And that's it.
Mr. Blood.
No objection to the first question. Objections to the next 3.
Tab asked if I'm going to debate Andrew Wilson. Let me clarify a couple things. People kept asking if I was going to debate Andrew Wilson. I would, but I don't have anything I particularly want to debate him on. Like I disagree with some of his positions, but not to the point where I believe there's a requirement for someone to like step in and counter him. I'm just like, okay, well, you believe stuff. I don't really go that far. That's fine though. It doesn't bother me. I did say I would be happy to have a discussion with him. I'd like to learn more about him at some point. Originally, he popped up on Twitter and was like, why don't you have me on your show then, you coward? And I was like, all right. And then he like deleted it. So it's like, I would. He's an interesting fellow. I don't have I don't want to be, I'm not a debate me bro. I don't want to get on there and scream at someone. I'm tired of those. Like, I'll do it if the cause is righteous, but like, I don't have, I think he's interesting. I don't think he's that controversial or that dangerous that I need to do that. But I would have a discussion with him anytime. He expressed that he didn't want to get involved in, quote unquote, that sector of the internet. I believe that he used to call into the kill stream a long time ago. So like, he kind of came up through the same ranks, so to speak, that I did. I don't want to be in there either. Like, I get it. I don't have any desire to get on a stream and scream at Andrew Wilson until we call each other slurs, even though that does give me some sort of non-sexual gratification. I don't want to, it gets tiring. So it has to happen organically. I don't want to go into a discussion expecting that. And that's what's happened in these other times. People are like, hey, I want to come on. I got some questions for you. It's like, okay, I'm in a mood. And they come on and they can take it any way they want. And actually, Duncan, Shane, those guys, I talked to them before the stream and they're like, yeah, nothing personal. We're not going to attack like your character. We just want to go back and forth on this. It'll be fun for the audience. And then immediately they're like, you're the worst lawyer ever. You have no ethics and you probably are a rapist. And I'm like, oh, okay, we can fight then. But like that's how they chose to go.
This is a transparent.
Why don't you debate Clavicular? Why would I debate him? I think the guy's fucking hilarious. I think he's great. All I want to do is listen to him tear people down. Like, I want him to be like, your maxilla is pathetic. You probably have no testosterone. And I'm going to prescribe you with bashing your face into a wall until you look like a fucking man. Like, I want him to do that to me because it makes me tingle. But then I also want to see him tear down everybody else. I just want to watch him make fun of people's looks all day. I think it's great.
Attempt to circumvent the court's 807 ruling regarding Mr. Norris by casting some sort of inference that what Mr. Norris would have testified to is admissible.
Did you earn that yellow tie? I should have gotten my white tie first and then graduated to the yellow tie. Nick isn't a master debater like Andrew Wilson.
This setup has been long in the making.
I only want to debate stuff that I've
After the court issued its
serious
807
passion
ruling, Mr. Norris called the Summit County Sheriff's Office. Deputies interviewed him, and he said he was calling on behalf of, he was calling because defense counsel told him he should call.
Catch you later, Wildling.
May we just pause here for a moment? I don't know that we need to go into any of that. I understand part of your objection to be a lack of foundation.
That is the beginning, Your Honor.
I think that's the beginning and the end of the discussion. There's no foundation for the premise of.
I like this tab guy. I think Nick would do well in a debate. If you want to know how I would do in a debate, just look at my stream with Tonka, Shane, Eric July, or Duncan McLeod. Any one of those. Or you can look at my videos going back and forth with just some guy. These are from years ago. It all depends on the subject. I'm not one of those guys though who like loves debate where they're like, yeah, I'll take that position and do it. Like I can do that, but I don't want. I'd rather learn something that someone cares about.
Your questions 2, 3, and 4.
I'm sorry, but I don't understand. We have been produced a report from the Summit County Sheriff's Department confirming this call was made and confirming that there was no interview of this individual. It goes not to the credibility of the individual. It goes to the credibility of the investigation that they chose never to even speak to him.
There is no foundation for the premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
It's like you could
I'm
just
sorry,
do
but
a
I don't
fake
understand
thing.
what you mean by there's no fact. There is valid.
The judge, I think the judge has kind of had it with the defense here, and it's maybe that's part of the reason that the defense, like that might have factored into their decision. The judge has been increasingly frustrated with the defense, and he seems to be a very patient judge who's willing to kind of like give the chance, and even coach people through like missteps or mistakes. But he seems to have gotten to the point with the defense where he's like, look, you need foundation for these things. You can't just make up whatever you want and then call it a question that is a basis in this case. And that the defense has done that the whole time. Like that has obviously happened.
From the state that this call happened.
It's not that did you interview a person named David Norris. It's the substance that is the premise of the question. There is no
What's up, Danny
foundation
Extreme?
For
Keep the
the
facts
premise that
at bay.
Eric had a prior
We need
history
you
of
in those
seeking
gaps.
fentanyl.
But that's not the way the question is worded. The question is worded is someone contacting you, asking to give you information about it, and you refuse to interview them.
That's not the question you asked. Read the whole question.
In order to
Makes her
properly
read it again.
investigate,
No. Go to number 2.
that is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Let me ask it this way.
Okay.
What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
That's a fair question.
It would be reversible error for me to allow that question.
He just fucking mogged her from the bench. He's like, let me ask you your question and see what happens. She's like, you know what? He's like, it would be error. It would be error. Look at that smile on his face. He's like, judges do help out like new attorneys. He's got to be frustrated with this fucking team. Like, again, Lewis and Nestor each have like 30 years of experience. And Ramos, I ambiguously aged because of the homosexuality thing, and probably a good skin routine. So I don't know, but like, I think he's probably been practicing a long time too. Let's see. Tell me about attorney Ramos Kouri Richins trial. Let's see. We've got Alexander Ramos is one of the lead defense attorneys representing Kouri Richins. Tell me about his CV and how he got and his This judge is your favorite of many trials that you followed. My favorite is still Borowski. He had more character and comedy potential, so I liked him. He's funny. But other than Borowski, this guy has been great. Yeah, Dan the Dev. I know it's on stream. It's fine. So let's see. He got his JD in 2014. So this guy's only been practicing, or he's only been He only graduated a year before I did. So let's see. He was assistant federal public defender before private practice. Private practice is Langford and Ramos, which is they leverage their combined experiences. Ramos' federal public defense background, Langford's 20 years of experience to represent clients in both state and federal courts. So federal claims, DUI and drug crimes, and zealous advocacy. So yeah, I mean, he was he graduated. Where was that? He graduated 2014. He would have passed the bar probably in, well, it depends on when the graduation was, but he probably passed it in 2014 as well and would be licensed. But he's licensed by 2015 at the latest, so 11 years. You know, he's an experienced lawyer, and it looks like this is what he's done the whole time is defense work. He's also the best lawyer on the defense team. He's actually the one of the three. I would pick him. Lewis and Nestor have been,
There were 2 residual exception rulings in this case. Let's be fair
Broken
about it.
Baker
Right?
is rating
That's
us.
absolutely
Oh my
correct.
gosh. Thank
So
you,
is
Broken
there a
Baker.
way,
Welcome
if
to
we
your
scrub out the
beautiful
reference
viewers.
to fentanyl and we don't get into the specifics of exactly what was said, because I understand their concern about that and the court's concern, which is why we raised this in advance, which is why I'm trying to do the right thing here.
I appreciate it.
If we just said that an individual contacted them with information about an interaction with Eric involving drugs, illicit street drugs, and they chose not to investigate it at all, it does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all other possibilities because they chose not to interview at least one person that clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
But I do think it's fair game to say, look, you've got someone coming to your office saying he tried to buy drugs from me and I want to be interviewed, and they are like, no, thank you. I think I'm entitled to get that in, and I'm willing to do it in the most ethical, careful, reliable, non-inferential way possible, but I do believe that's fair game. And I'm open to suggestions. Whatever I need to do.
These 4 questions are not it, Mr. Blipper.
These 4 questions are
You look
not.
like you're about to say something. I'm sorry.
No, Your Honor, as I understand the status quo is the court's, I guess this court has sustained the state's objection to those questions.
I have. I think what Ms. Nestor is trying to ward off is another set of objectionable questions that are maybe more general, less specific, some version of probing the bounds of the state's
You can probe.
investigation of the charges. Yep.
Your Honor, no. It's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to suggest otherwise, or to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative has been so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may that there may be admissible evidence.
May I respond?
Yeah, hear me out for a second.
Sure.
Or let me make sure I understand the balance of the argument here. You said there's no admissible evidence that Eric Richins sought fentanyl. My sense of the evidentiary record
It's
so
another
far
time,
and the
because it got
evidentiary
criticized.
record, or the universe of admissible evidence that's available, is that there's no admissible evidence that Eric Richins ever sought or received narcotics except through a prescriber. Correct?
Correct. The only admissible evidence that's already
I
admitted
think it's his knee surgery,
is
right?
a 2016 hydrocodone prescription following knee surgery.
Right, okay. Very good. Now,
The defense-
by the same token,
Never.
I believe all the admissible evidence
any testimony
of Ms.
about-
Richins seeking or receiving
fentanyl.
narcotics of any kind is already in, correct? And all is putting it strongly, but
Yeah.
That is, to the extent there was any admissible evidence of Ms. Richins seeking fentanyl, it's either in or it's not admissible. Let me say it that way.
Or it would come in a rebuttal case.
Understood. Okay. Which was the basis, among other things, of, not the basis, but is related to the court's exclusion of the offered statements of Hayden Jeffs to his sister.
Right. Right. So I do wish to correct Mr. Bloodworth's statement that we have fully dispatched Mr. Norris's proposed testimony. To the contrary, the court was very clear that you are accepting, for purposes of your analysis, that everything in the affidavit that Mr. Norris provided was true, and that you did the analysis, the court did the analysis
Don't tell judges what they did.
based on the law of the hoops you have to jump through to come under the residual exception. And for purposes of your analysis, you did not go into an analysis of whether Mr. Norris's testimony was credible, not credible. You just said, I'm going to assume for purposes of this ruling that everything in that affidavit is true. And then I'm going to rule on whether it fits the residual exception. And the court went through a very thorough analysis and decided it did not. So I don't think that's a fair statement that he just made, that we fully dispatched it like there's nothing behind it. That's never been litigated in front of this court, nor have we asked it to be.
The difficulty here, though, is imagine David Norris were on the stand.
Right.
And you asked him, hey, did you ever contact the Summit County Attorney's Office, or Sheriff's Office? My apologies.
Yeah.
He says yes. And then you say, what did you tell them? It immediately provokes a hearsay objection that I've already dealt with under my ruling on the residual exception.
Absolutely.
He is getting annoyed with that too. They keep probing him on things he's already ruled on. I saw something. Who asked? Someone asked, I think on Rumble, if this is if that was IKEA furniture. Who are you talking about? Like, or what IKEA furniture are you talking about? I'm just curious.
So
and we don't,
if you want to elicit testimony that, did you ever speak to a gentleman named David Norris? Yes. And then move on, fine, but I'm not sure how that's relevant.
well, that's meaningless to a jury unless I can say, was there a gentleman named David Norris who tried to give information that would have supported the first hypothesis?
But that's the hearsay problem.
But it's not being offered for the truth. It's being
100%
offered,
being offered
Your
for the
Honor,
truth.
if I may please, it's being offered for the same reason they've gotten in a ton of other hearsay in this case by the impact it has on how they did their investigation. They got that in through Woody. That's how they got in Woody, the Amy and Katie's statements, because it wasn't for the truth of the matter that Kouri tried to kill him before. It was how it impacted her investigation from there on out. This is the same exact argument. It's how the fact that they got that information and chose not to even investigate it, how that impacted the hearer. It is irrelevant for purposes of the the truth, and the court can instruct it like you've done over and over and over for their witnesses when we had this exact same argument.
If that's true, Ms. Nestor, then
Yes.
the 807 residual exception wouldn't exist and it wouldn't apply. It does apply, and so you can't use this argument to undermine that.
I know, that's why I'm trying not to undermine your ruling.
That's why the substance of what he told the Summit County Sheriff's Office can't come in.
And I think I could maybe craft a question where we leave out the juicy substance and just say there was an avenue that you chose not to investigate. But I've got to get something in context so the jury understands, hey, you had this road, you chose not to go down it. That was your choice.
I appreciate why you want to present this to the jury, but there are limits
Right.
on both sides of the V about what gets presented to the jury. And those limits are in part defined by the Utah Rules of Evidence. And this substance cannot come in under the Utah Rules of Evidence. For the same reason that the state could not argue that we want to get in Hayden Jeff's statements to his sister just for the effect upon law enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario which we're going to be allowed to question him about choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communication.
You would have to have an expert come in that you would have had to announce and then be subject to cross-examination, like they tried in Edgecombe, to testify about how an investigation should have been done. That's what you would have had to do. You can't just, was your own investigation insufficient? Like, what a stupid question. What a stupid line of questions. Why would the judge want to waste anybody's time with that? You have to have something come in to challenge that ahead of time. And if your theory of the case is that they did an insufficient investigation, you should have gotten a certified investigation expert, someone who has trained other investigators, someone who's been an investigator specifically for X amount of years, et cetera, et cetera, et cetera.
If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County Sheriff's Office and said, I was in Utah on that day and I saw it happen, and the Summit County Sheriff's Office chose not to investigate it, would we be having this conversation?
That's not this circumstance, though.
It is the same, though, because that evidence has nothing to do. Here, it's even worse because it's inadmissible.
It's inadmissible from Mr. Norris's mouth, but I don't think it's inadmissible, period, in terms of if it was part of an investigation that was ignored or not followed.
The substance is inadmissible. The fact that they spoke to David Norris as a fact is admissible if it's relevant, but without the substance, it's not relevant.
We have just a moment.
Of course. Let me just take 5 minutes.
5 minutes? That's all you get.
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break, any other issues before we invite the jury?
No, thank you, Your Honor.
Mr. Bloodworth?
No, sir.
Okay, I'll be right back. Thank you.
Good evening, sir, or should I say sensei? What is up with the yellow headband?
Nothing specific. Someone mentioned something about it, so I just decided and it happened to be next to me, so I just decided to tie it around my head like a proper, normal, well-adjusted person would do.
Certainly you can slowly slide that silk nightgown down off your shoulder. Oh, my Mormon God, I want to hold her, and I thought my heart told her, but it turns out I sold her a lie with this leather tie.
Thanks, Judge. Thanks, Judge. We do have the judge's voice available on Super Tips. Just, in case you're a little lonely at night and you need some inspiration. Look at Kouri. She's like, am I getting arrested yet? Am I going to prison forever yet? Is that what's happening?
All right.
Thought I was color matching the perp's yellow shirt. That might have been part of it. I don't quite remember. DOG King Cam, you weren't here earlier. I'm not commenting on this situation, but no, I didn't have anything to do with it. I don't want anything to do with it. He can go do whatever he's doing. That's up to him. I don't give a shit about it, so I don't have any comment. But no, I definitely didn't do that. Nor was I asked, like someone on Twitter just said it, and people believed it. But no. Here we go.
Us to revisit the court's decision yesterday.
The court's decision.
It's out.
Hold on, I gotta get back to the
250139. Record in 231500139.
Wait, what are you talking about?
Counsel, thank you for your patience. I've
Get
just
me in
handed
trouble
you
for
a
what?
copy of State versus McCullough, 2014 UT.
Wait, like, is this a serious thing, Real Patriots Party, or are you like making a joke that I'm missing the context of because I'm tired?
TF 215. Need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Jeff's statements to his sister. Pause for a second. I need you all to be very thoughtful about this. I can't unring the bell once this information is out, and sitting here at the moment without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state's state is not prosecuting with one hand tied behind its back. Mr. Bloodworth, I cut you off.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, it would also cause us to revisit the court's decision yesterday regarding Mr. Bonsavage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive me. Oh, I think I do. Yeah, a little bit. Now, let's talk about foundational requirements. I gave this a little bit of thought after
Sleeping Psycho.
rereading McCullough.
I wouldn't have a tie around my head. I
There
have some
is
fishnet around my
some
head.
precision.
What are you talking about?
And some technicality into how these questions would need to be asked.
One of the most fun things, like going back to this real quick, it's nighttime. Like we take a little detour. One of the most fun things Lady Rackets and I ever did was we went to 80s prom. Like we saw some stupid flyer for an 80s prom. You know, we were married, we were graduated from college and stuff, but we we got to dress up like the 80s and go, and it was a fucking blast. Nothing in that building was from after 1989.
For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement into question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do? This information, this statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. And I'm not sure Detective O'Driscoll.
MTNTK, make sure on your subscription thing that you actually pull it up and click the notification bell and ask for push notifications, and make sure they're enabled on your phone, which is too many steps, but that's what you got to do. Or you can always just sign up for locals for free. All you need is an email address, and you'll get an email every time I'm going live.
Driscoll's that guy. By the same token, to the extent the state would want to ask or show that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Hayden Jeffs to his sister, Aubrey Jeffs, or information received or is told by Mr. Bondsavage, they're going to have to call a witness that had personal knowledge of those statements and then lay foundation for what occurred next. We can't skip steps.
Your Honor, agreed. There's a little more to unpack here too, because I happen to know that Jeff O'Driscoll's not the witness for this. We would need time to prepare the witness for this. We also have the problem that
being cryptic as fuck.
We meaning
the state.
The state. May I ask you just a procedural question before you keep going?
Yes, sir.
Imagine that at some point, imagine it's not Jeff O'Driscoll, as
Right.
you suggest.
Right.
And imagine in the defense's case, they find or call the witness who received the phone call or talked to David Norris. So they call David Norris.
Sure.
And they ask, did you call Summit County Sheriff's Office? Yes. What did you tell them? Did they ever follow up with you?
Yes.
I imagine the state's response to this and the state's offering evidence regarding how it responded to information regarding the Hayden Jeff statements and the Nick Bondsavage statements, that would come in the state's rebuttal case. Is that correct?
Not necessarily, Your Honor. I mean, we haven't rested. I think
Fair.
we would like to get out in front of this before a rebuttal case. And while the state has investigated David Norris's statements and to show how they're not credible, the state pulled up on investigating how Norris came about.
We've done a little
And
bit of that.
The state would
D.
want
Brown.
to continue that investigation.
He's talking extra slow
I
today.
think I know what you're talking about, but in terms of how it came to be that David Norris contacted law enforcement when he did.
Correct.
I don't know that I have any authority or interest in ruling.
I don't think you.
Yeah.
I don't think so. My only point in mentioning that is it would just take a little bit of time, and it would be necessary. The other point, I think, well, the other objection the state has is under 403. I think in proceeding in this manner is both prejudicial and confusing the jury.
If I let in everything, though, so Norris, Jeffs, Bondsavage, does that ameliorate any unfair prejudice or 403 concerns? And when I say let it in, I mean as premise for questions regarding the scope of law enforcement's investigation, not for the truth.
I appreciate that, Your Honor.
I tend to agree with you if I let in only one side.
It's interesting because both that assumes that the weight of unfair prejudice or the weight of confusion is equal on both sides. The state, I don't think it is. I think because of the complete incredibility of David Norris's testimony.
Spit it out.
How David Norris came to contact law enforcement, that prejudice and that confusion is much weightier than.
Something Wong says, can just fast forward the sidebars. There are no sidebars left. This is oral argument that is closing out. This is going to close out their cases. They're both done. They'll both rest after these arguments are done. So that's why I'm not fast forwarding right now. I didn't realize he'd be talking this slow, but I heard there's some spicy moments in some of this argument, so I'm waiting for it to happen.
Confusion related to recorded interviews with Hayden Jeffs while he has counsel and a recorded jail phone call. There is no doubt.
Doesn't that weigh in the state's favor, though?
No, Your Honor, because I guess the question is whether it's unfair prejudice or confusion. Confusion, it doesn't, David Norris's the purported effect on law enforcement of David Norris's is even way more confusing than the effect, just because the information provided to David Norris is highly in doubt and would be highly litigated, whereas the information Hayden Jeffs provided is recorded. There is zero doubt about what he provided. And the information that Nick Bonsavage provided is recorded. There is zero doubt. We're not bogging down into some mess of who said what when.
When you say the information, you mean the substance of what David Norris told Summit County Sheriff's Office a number of weeks ago?
Correct.
Okay.
Because it's changed. It has changed over time. We have affidavit number 1 from defense, affidavit number 2 from defense, phone call from David Norris, interview of David Norris. What David Norris says is a moving target, and it is a moving target based on when he speaks with defense counsel.
Forgive me. What is your understanding of the evidentiary landscape as to how many times David Norris has contacted the Summit County Sheriff's Office? Is it once or more than once?
I think he's had 2 contacts. Once he spoke with a patrol deputy to take kind of the initial, well, I guess there's once a call into dispatch, which was non-substantive.
Okay.
Then there was an initial contact with a patrol deputy, and then there was a contact with a detective.
Okay.
And then we have the affidavits that he'd submitted, that defense has submitted in the 807 litigation.
But those were submitted here, right, as part of the 807 litigation. Did those ever go to Summit County Sheriff's Office?
I don't know one way or the other.
If it's no, then those don't get shown to the jury, right?
Just to clarify, they weren't affidavits. We just laid out a statement of facts in our motion.
Okay.
It's a proffer.
It's a
Maybe what you're
proffer.
referring to. I'm a little less clear on
Sorry.
It's a proffer.
Yeah, proffer's the.
I'm not sure the proffer has any impact here. I'm not sure the jury would ever be made aware of the substance of the proffer. They, as I understand it, under McCullough, would only be made aware of evidence related to the substance of what Mr. Norris told investigators and law enforcement.
Your Honor, the proffers do tie into this in that the question would be, did this inform your investigation? Yes, we considered all of his statements.
Hey, thanks, Peachy.
To include the defense proffers in determining
Also made
that
sure to
they
keep
were
my
just flat out incredible.
proof of jump kick skills.
So that goes to
on
kind of the
for the
confusion argument. So in the 403 analysis, Your Honor, I do not think the weight of unfair prejudice to the defense is
Lucille,
the
I'll
same
go
as
find
the
it.
weight of, well, any of the 403 factors. I don't think the weight is the same for the state and the defense.
And to put a finer point on it, you're concerned that the jury would be confused about who said what when? It's jury confusion that I need
It's
to...
jury confusion.
Right. And
Yes.
so what is it you believe they would be confused about?
I think they would. I think they would be confused about.
Oh my God! Answer the fucking question. Askili says Nixon. Yes. Nixon. How you doing? Mike Milichek says, I know you came back some months ago, but good to see you being even more active. Love the podcast with Camelot last night. We'll get used to it because we're going to do it every Wednesday night. We'll alternate channels for now. But yeah, it'll be me and Camelot, a little bit more relaxed, a little bit more laid back on the topics. You know, we might talk some legal stuff, but we'll probably not. You know, he's not a lawyer. We're going to talk other stuff too. And I hope you guys join us for that. Right now, he's got it set up for 9 o'clock. We'll have to talk about that because up until summertime, that it's a little early, like 15 minutes too early for me, but we'll figure it out. Stupid April says, I feel like I may have stumbled into something I may not understand. Just a casual yellow tie in your head. Okay. Like, yeah. What do you want me to do? A formal yellow tie on my head? I'm very confused about that. I'm very confused. Let's see. Oh God, that's a horrible. That is a horrible picture. Just a second. Oh wait, I can just put. Oh gosh, I love this new thing where I can just drop this into locals. Whoops. Look at it. Look at it. It's so gross. All right, back to it.
The effect on law enforcement, which is really what this grounds in, right? This is the effect on the hearer, the effect on law enforcement.
Okay.
And I think those waters would be so muddied in the case of Norris.
Speaking of muddy waters, I'm about
those
to run to
waters
the
are crystal
bathroom.
clear in the case
I'm about
of
to run to the
Hayden Jeffs and
bathroom
Nick Bonds.
right now. What is this?
Sometimes I feel I've got to run away. I've got to get away from the pain you drive into that micropene.
I'll be
Keep the
right
headband.
back, guys.
It is a symbol of
right
unrelenting
back.
masculinity and non-compliance.
Okay, I'm back. Whew. Hey, what is up, bittersweet heart? Nice to see you.
Savage. And the waters are muddied as it relates to Mr. Norris very deliberately. And that and I don't know that I suspect the purpose is to confuse the jury.
No, I did not go for an
As you
off-cam
sit
fart.
here today, do you
I went to the bathroom. I went to go pee.
have you identified the witness that would testify regarding investigators' knowledge of and response to statements made by David Norris?
I know. Yeah, I don't remember the name. I know the patrol officer. I think I know who he talked to. I think I know who the detective talked to. It also involves my office, right?
He sounds like he's really nervous.
You
So
would be able to call an investigator, not a lawyer, right?
right,
Yeah.
I think these guys by the end of the week have not
so-
slept very well.
probably 3 witnesses.
Okay. And then who are the witnesses you would call to testify regarding the state's knowledge of and response to Hayden Jeff's statements to his sister? Or, I mean, I appreciate that Hayden Jeff spoke directly to law enforcement in a recorded interview.
Right, that's what we would have to get into. What did you understand? Why? With what level of detail? Which is extraordinary. Here's
And there, as I understand it, the state's position would be, well, if we're not admitting it for the truth, Judge,
Stupid April, definitely. Will and I have talked about doing another show. We haven't put it together. I'm like not enmeshed in the Karen Reed world right now because like the trial's over. And I was going to follow some of Aiden's stuff, but it was like, this is too complicated. This is too complicated and too many people are banging each other, which I find funny, but like I don't know how to catch up to all of that. But yeah, I would love to just like, do a good old fashioned stream with him, with Jimmy as well. I'd love both of those guys and would be happy to do so. Okay. Oh, what is this? Why would you do this? Boosh, what is wrong with you?
Bop ba-doo ba-doo bop ba-doo ba-doo bop ba-doo ba-doo. Yay. Shut the fuck up, Nexter. We're all tired of your shit. Micropene mic down, bitch.
We'd be happy to watch you talk about literally anything else. Yeah, this trial's going to be over very soon, actually, though. It's finishing out faster because the defense just decided to not. Which we're going to get to in just a little bit when they make that decision.
there's no Crawford problem, so the recorded interview comes in.
100%.
Okay.
And the same thing, by the way, with the Nick Bonsavage jail call.
Nick Bonsavage!
That entire jail call comes in lock, stock, and barrel.
Whoa.
If we're going to mention it, we're going to mention it all.
Oh, I understand.
And then can I just say one final thing on the unfair prejudice?
No.
I think the court, in considering the weight of the various prejudice.
Defense counsel.
The prejudice.
Oh, I got that wrong.
Admitting Norton versus Norris, versus the prejudice of the Hayden Jeffs and Bonsavage. I think the court needs to in the probative value part of that analysis, I think the court needs to consider kind of all of the corroborating evidence and the fact that David Norris's assertion
Peachy, we'll get back
is
to that.
not at all probative.
That's the thing with trial streams. Unless a trial is overtly political, like, you kind of get focused into one thing, and it takes so much time. It takes so much time to do them, which is fine, but it makes it difficult to do other stuff.
Because there is nothing that corroborates it, and it is inconsistent with all the other evidence in the case, whereas the Bond Savage statement and the Hayden Jeff statement is highly corroborated with a ton of admitted already evidence in this case.
And just so we're clear, when you're talking about probative value in this context, we're talking about probative value to the defense's theory of incomplete investigation and probative value to the state's response to that theory.
Correct, under the 403 balancing.
I understand your position.
Okay.
Ms. Lewis, Ms. Nestor, Mr. Ramos, this is high-stakes poker.
Yes, it is. I was just going to ask
poker.
you if we could
I
have
don't
a
want
little
any of
time
you on
to
my
meet with
team.
our client next door. She's got some decisions to make about that.
I want to make sure that you explain to her that if you're successful in persuading the court that the
Dude, Bloodworth,
substance of
he
David
seems like
Norris's
he's
statements
done.
should come in not for their truth, but
It
for
is
their
early in
effect
the day.
upon
So.
law enforcement and investigators, for their probative value to the defendant's theory of incomplete or incompetent
You can't fall asleep.
investigation. That
You can't fall asleep.
by extension, my view is that I need to allow the state to respond to that theory by, among other things, admitting evidence of their knowledge of in response to statements made by Hayden Jeffs and Mr. Bond Savage, not for their truth,
Needs to
but
prove crystal meth
to
just to not
show
sleep.
what they were
Bloodsworth?
doing and
Yeah.
how they were doing it.
What's he going to do? Prosecute himself?
Can I just get a clarification on the Bond Savage? I want to make sure I'm on the same page.
Why don't we just get a proffer of it, Mr. Bloodworth, so we're all hearing the same thing at the same time?
Yes, Your Honor. In a March 4th, 2022 jail call between Mr. Bond Savage and an inmate in Gunnison, they're discussing purchasing a PlayStation controller, and they're discussing
Probably two members
who's going
stream
to
this
pay
weekend.
for it, kind of how to get the money for it. And
Wimig 43 at 339 says sunglasses indoors at night. I know. I know. Like, think about it for a little bit. Like if you just ponder it and think about it, like, whoa, sunglasses indoors at night. Ponder it. Ponder it. What's your conclusion? Like, where'd you go with that? I bet it was on an adventure. Holy fuck. God damn. I can't imagine the halls that you have tread with that philosophical endeavor.
Nick Bond Savage says to the inmates something like, Carmen will cover it. She just made money selling fentanyl.
So this is already in, other than we
The word
substituted the word fentanyl
We
for
illicit street
street drugs.
Right.
That was nice of you. Thanks, guys.
And that's a recording,
It is a recording.
as is Hayden Jeff's interview with law enforcement.
And the upshot proffer of that interview, and this occurs many times, there's pages of transcript on this subject, but the upshot of the proffer is that Kouri Richins asked me to buy her fentanyl. I explained to her, in really colorful language, how dangerous it is. She wants to stay away from it.
You described it to her
Who
in
on earth
colorful
would
language?
want fentanyl. And then there's a second phone call where she calls back and asks for the Michael Jackson stuff, and they get into a propofol discussion.
Oh, no. Okay, he was talking about someone else. I was like, why are you
Okay.
telling her?
How much time do you want, Ms. Nestor?
We have 30 minutes.
It's fine.
Thank you, Your Honor.
Yeah, Jarvis
Anything else
wants it.
before we take a recess, Mr. Blover?
No, Your Honor.
That's pretty
Ms.
amazing.
Nestor.
No, sir.
The
We'll be in
attacker
recess
at,
until 10:30.
what university was that? Old whatever. The mass shooter to be was trapped by some ROTC students on campus and made to no longer be alive. It's like, holy shit. Oh my goodness. Summer breeze makes me feel fine. It's like the people asking about the yellow tie headband don't know Nick at all. I love it. Nick doesn't give a fuck, and that's one of the things I love about him. That is correct. That is correct. Let's see here. He teleports in. Scott Ritter was having terrible eye problems last week. Everybody is stressed out. Scott Adams' eyes are really going south pretty quick too, from what I heard. Who's Scott Ritter? I don't know. I don't know that guy. Yeah, Old Dominion. That was the college, university, whatever it is. Locals is going nuts. Locals has issues, but I don't know what to do about it. Was that a self-esteem song by Offspring? Man, she's got issues. Or is that might just be She's Got Issues. She's got issues and I'm gonna pay. Isn't Scott Adams dead? And Ritter is the weapons inspector from Iraq. Scott Adams is dead. That's why I said his eyes are just deteriorating.
231-500-139.
Record speed right now.
Counselor present, Ms. Richins is present. Ms. Nestor, you've had an opportunity to confer with Ms. Richins. How does the defense want to proceed?
Thank you, Your Honor. Thank you for the break. We appreciated that. So we have reviewed the case.
She put a
We clearly
Quiz knows
understand
how
the
to
court's
business.
ruling that if any of it comes in, all of it comes in. We get that. We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation in good faith that Officer O'Driscoll, he's out still, right? He is not the foundation witness because he is not the individual who communicated
Scott Ritter.
with Mr. Norris. And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which we accept as not him. So to avoid confusion now, since it's not him, we will wait and not ask the questions that he doesn't have.
I think we're still on cross and then redirect of the last witness.
Because it's like you said, there's no way to ask the question without introducing the substance. We couldn't figure out how to do that. So we're going to wait until we have a foundational witness, and then we will proceed that way if we can lay a foundation.
Okay.
And if we decide to go forward with that evidence,
I appreciate that. If you make that ultimate decision,
we'll give everyone a heads up.
I appreciate that. And one of the reasons I would need that is to make sure I give defense an opportunity to state on the record, or at least summarize on the record, their strategic balancing of the risks and benefits so that there is a record of that going forward.
I appreciate that, and I think that's probably a good idea for everyone,
Okay, very
including
good.
us.
So, Mr. Bloodworth, because the defense will not be opening the door to any portion of its incomplete investigation theory related to David Norris through Detective O'Driscoll, I don't believe the state would be permitted to respond to it yet. Is that your view of it?
That is my view of it, Your Honor.
Okay. So, as a matter of status quo, we are going to proceed with additional
Who hates
cross-examination of
Scott
Detective
Adams?
O'Driscoll, correct?
I don't hate Scott Adams. I just wanted to make
Did
a joke
we
about
reach
that
an...
person.
Well, I'm
I
sorry.
figured he wouldn't care.
Could we just go ahead and, well, I can just do it through, I think we decided I would just ask him about 340. I'm sorry, nothing.
Yes, that
I
is the
apologize.
defendant in the
I
yellow
withdraw.
I was
blouse.
about to ask, did we reach an endpoint regarding 340 and the photograph?
So the plan is to introduce the stipulated 340, which we'll get in, and then I will ask him if he can identify the photo. If he can't, he can't, but I'm going to try.
Okay.
And I'm not going to get into the substance of any of the bubbles, and I'm not going to introduce the bubbles or any of that.
The bubbles.
The only thing I'm going to display to the jury will be the picture on 340, and then I may have it side by side in front of O'Driscoll so he can compare and refresh on the one that's not getting introduced.
And to the extent you ask him about whether it was sent as part of text messages between
Only the date.
Eric and Kouri on the date, it's a yes or no question.
Correct, just
Okay.
on the date, not the time, because I don't want to confuse anyone or require UTC time or any of that conversation. And the time really is irrelevant to us.
Okay. Mr. Bloodworth, anything further on that?
No, Your Honor.
All right. Are we ready for the jury?
Yes, Your Honor.
Ms. Nestor.
We are, Your Honor.
Doug, please.
There we go. Nick, why are you wearing a tie on your head? Look, I had to lock my thoughts down. They were wandering all over the place. And like children, you can just tie them up. To be fair, he's not dressed like Che Guevara. He's dressed like the guy sucking off Che Guevara. Judge is like, God, I want those chips. I really want a bag of chips. Man, I want a bag of chips. Like, how am I going to get one of those? I wonder if I can call a recess for a bag of chips. I wonder if anybody's going to ever just do a super tip voice of someone talking while eating chips, like obnoxiously into the microphone, just like handfuls of chips at a time. Just read like the Gettysburg Address with a mouthful of Lay's and see how that comes out.
Okay.
We can call it potentially cardiac arrest. Who just put in a Nick pouch? I didn't see it. I've never used one of those. I don't like, I just vape.
All rise for the jury.
Please have a seat as you come in.
What's up, Urban Angst? It's your bedtime, so what now? Well, you have to come here and get yourself in a nightie.
All right, have a
And,
seat. Thank you. Ladies and gentlemen,
Just
thank you for
join
your
us in
patience.
degeneracy.
We will now proceed with additional cross-examination of Detective O'Driscoll by the defense. Detective, let's have you come in the courtroom.
They
Detective,
do
please
get
step in
pricey,
front of Brittany. We'll get you
especially
sworn
because
back.
I just suck them down.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
That's truce underwear. I did not inhale, not a single time. On the woman, I did on the cigar.
Ms. Nestor, please proceed.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when
Waiting for
we
this-
stopped
love this cross.
yesterday,
Let's do it.
we were talking about the GIFs or GIFs. And I want to start by
Get it, Naval Brick.
having you review a document that's been agreed to by the parties. It is exhibit number 3-40.
No, the reverse
And at
pyramid.
this point, Your Honor, we're
It's like a
asking to
lifting
admit it
schedule.
per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
If any one of you
Please.
Mr.
marries
Ledward.
Corey while
No
she's
objection.
incarcerated, I will
State's
personally
exhibit
send you
3-40
$10.
is admitted.
But I will
Alright,
stamp
and
the $10 bill with
This was
each
talked
nipple.
about when
in a different color of your
I believe it
choice.
was Mr. Kostradimos, I think, it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were
This is
in
the
kind of a
GIFs.
group, and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question?
Gifts.
Maybe blow that up at the top.
Can't blow you up.
Okay.
Already done.
So I think that's two of them. One of them is from, I guess, the movie Dumb and Dumber. And the other one is our
LMAO.
president. And I think there was a third one, but it's, yeah, Mr. Spacey and in a TV program, right? And those are the three GIFs that were talked about. And if you blow up the time,
She's the only person on earth who calls Kevin Spacey Mr. Spacey still. Probably Suits, right? That's what I would imagine. The Trump one was, I'm really rich. God, don't you wish it was Eric sending Corey, I'm going to come?
that they were accessed, they all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr.
Yeah, he's dead. They're all accessed when he's dead. They were created when he's dead. He's long dead. Right? Because he died around 3 a.m.
Richins was found deceased, correct?
Correct.
Right, and I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and
Samson
exactly when
GIF.
they were sent or
hungry.
who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Kostradimos, yes.
Okay, can you pull up another one of the photos that is the picture from the house? That's it. All right. This is another picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture?
Quiet
Right above
Boosh.
it, I think.
Also true.
There we go. Can you blow that picture up a little bit? Thank you. All right. And is that also just a closer up view of the Legacy Mansion?
It appears so. It's very blurry on my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen.
So, guys, not only is the defense going to not levy a defense, the defense right now seems to be putting into evidence that as Eric's body is still cooling, bleeding out, and staining the carpet next to her, she's looking at Midway and looking at gifts of Trump going, I'm really rich. Like, that's what she's doing at 10:42 in the morning when he's pronounced dead at like 6 or something. I'm confused. What the fuck? How do they think this helps? They got to fix this up.
Exhibit JO, I think it's 11. Not for the publication yet, Your Honor.
Understood.
All right. And can you
What's up, Adriana
take
B's
just a moment and
Custom
blow
Furniture?
that up just a little bit so he can read it better?
You are late. You might want to get a text.
Just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Somebody
Your
has
Honor,
to be behind me.
Objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure, and it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed?
Yeah, I get it. Well, Treasurer says they're trying to argue that it was really Eric who looked at them and they didn't investigate it thoroughly, which that would be crazy if Eric looked at them several hours after he had passed. AJ Olson says the defense is saying that she got these gifts the night before he died. She didn't open them until the next morning. Yeah, I get it. But it's 10 a.m. Your husband's a corpse. He's been dead less than 6 hours. And you're like, you know what? I'm going to look at these gifts. But they're probably accessed just by her opening her text messaging app and looking, like scrolling through it. I guess maybe that's what they're going to try and get across. But either way, like this doesn't like hurt them. This isn't a nail in the coffin or anything, but it doesn't seem to help. It could hurt them. I don't think it would. I think the case is already pretty solid, but it definitely doesn't help to get to elicit this testimony. I don't get why they're trying to do it.
That day.
Don't
Not
draw
all.
attention to
Some
shit.
of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection?
See you, Jacob
as to
Castro.
what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
Your Honor, I think the objection foundation, I think there requires additional foundation.
I think the question pending is, are these among the things he reviewed, correct?
So this can you
Maybe
do
I
right? It's a
misunderstood.
tie. It was
That's the question.
invoked
So I think
Can we back up a step, maybe? I'll
and
catch up.
summoned, so it
Sure.
appeared.
Ms.
But I was already
Nestrasko,
wearing a
ask
tie.
question
Where
one
was
more
it supposed to
time,
go?
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
please? Go one step before that. He hasn't seen these yet. He doesn't currently have them in front of him.
Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
All the texts from his phone
Yes.
on the day that
Thank
he
you,
the day
Arklux.
before he died.
Yes.
I don't remember all of them. I remember some of them.
So then, would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Bloodworth?
No, sir.
Okay. The witness can now see. what
Yellow
you're
tie is
referring
just
to, Mr.
tied with a basic
Thank you, Your Honor. And can you
single
go down
loop
just
and
one
tighten
more?
the leather.
And maybe blow that up a little, that photo.
Leather keeps it together.
Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally
Purple tie
correct,
doesn't
because
go
he
with the
died in,
suit. Oh, his
we
tie.
think,
His
the
tie.
early morning hours
His
of the
tie's
4th,
great.
right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes, Your
So,
Honor. Sorry, objection. Foundation is the meaning of died.
Thank you, Adriana.
Right, he was pronounced dead.
I think the witness and the questioning lawyer have a common understanding here. Overruled.
thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor,
Oh, yeah. And Corey's collar is awful.
objection. His recollection has been refreshed. I think the
Muppet-
exhibit can now.
Muppet Angela, the defense attorney is an idiot. She's fucking dumb. She's been bad the whole trial. So's Wendy Lewis, the other lead counsel. They have gotten lost in their own tests or their own questions, their own cross-examination. I mean, cross-examination is the story that you tell by making someone say yes. Like, that's what you get to do. That's the rule. How do you get lost on cross? Just make them say yes to the shit you want them to say yes to. Why is this hard? It's hard because they're bad at their jobs.
Be set aside.
I'm not publishing it. I've just got one more question about the photo and then I'm done.
She's actually pretty
I'll take it down.
in a
Ask your
female
question.
Addy
If you
way.
need to refresh again, you can.
Okay, thank you.
If she had,
Wait, did you tell me I could ask the
just
question?
volume, like if she lets
You
her hair
probably
down,
took the photo down.
add
Ask
some
whatever
volume
your
to it.
question
Yes,
is.
I think she's very pretty.
Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was
Duke Chronic says can't lead, but they can be crafty. No, they can lead. This is a hostile witness. First of all, it's cross-examination, so they can lead. Second of all, even if it weren't cross, if this were direct, that is a state actor, an investigator against Kouri. That's a hostile witness by definition. They would just have to request the court's indulgence and say, hey, we want to treat him as a hostile witness and we'll be asking leading questions, Your Honor. And the judge should have no problem with that. They're going to get to ask this guy leading questions no matter what. Like, just get him to say what you need him to say. Yes, no. Don't let him narrate. Drag him as best you can and then get him off the fucking stand before you realize, or before the jury realizes what your client wrote down.
the corner of the Midway Mansion.
Your Honor, the photo's still up on my screen and the witness is
My apologies. There you go.
staring at it.
Sorry.
The witness is
Is it the same photo, sir?
This one that we just saw that was
photo
enlarged,
was
you're
it?
asking if that's the same as
Is it hot?
the
Share with us.
one in the text message.
Does it match the one that we just put on the screen for the jurors that
Her
came
outfit
with
to a
all those
hard-boiled
other
egg.
pictures that morning?
only if you accidentally
Thank you.
cracked
That's
it
all
and
I
didn't know, and it
done with-
pops out through the crack as it cooks.
I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Of course.
She elicited the most pointless testimony from this guy. Worthless. Why bother with these questions? There are other questions she could ask. I'm going to say the gayest thing I
One more
possibly
step.
can.
If we could go back to 340, which has been
Really sorry.
admitted, and pull up
I have
some
a Melissa
additional
Etheridge
gifts
song stuck
that were
in my head.
accessed
It's
at that same
lodged there.
time. If we could pull those up, please.
Sure. There you go.
Okay, so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Yes.
And that one was accessed at 10:42 a.m. the morning of the 4th?
Yes.
And the one with the champagne is also that exact same time?
Yes.
And the one with the farmer is that exact same time?
So she probably opened her text message thread. That's the last time, or that's when those images were accessed. There we go. Nailed it.
Yes.
And we know for sure that the one on the bottom left was sent the day before.
Objection
Because we
calls
just
for
looked at that,
speculation.
right? And you refreshed your recollection.
Yeah, I don't know if the
He's not the
part
technical
of the
expert.
extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect, thank you. Okay, we can take that down now.
Holy shit, Aussie, that is so good.
I also want to talk to you about, sorry, startle me. I also want to talk to you about the
Adriana says, wait, I just went to send you money via Venmo and can't find your name. Didn't you used to have Venmo? I do still have it. Give me just a second. Maybe that one is weirdly under my personal name. Oh, wait. Don't look at my searches. Hope that's wrapped around me is cutting through my skin. Fucking, it snuck in. Melissa Etheridge song. You have to recreate that outfit for real? Yeah. Aussie, can you DM me that so that I can do that? I'd like grab it myself, but I'm doing something else and I'll forget. Hold on. Trying to remember my password quick. What? What? That's impossible. Oh, here we go. Send the code. Okay. Sorry to be a pain. Okay, this one is actually at Nick-Ricada. I wonder if I can change that real quick. Yeah, we don't want that. We're going to change that to Ricada Law real quick. Okay, now, there we go. We're there. So Venmo is now active, and oh my goodness. Not that anybody ever has to use it, but if you choose to, it's now there. I apologize for not having it there earlier. And I forgot to check to see if we got any locals members today. Okay. No, we did not. Okay, I didn't think so, but I forgot to check the messages. Oh my God.
The Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Kotradimos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them, and that they differed from the action in the phone that showed that a link
Bro,
was actually
MG,
clicked
that's
on
some
from
bullshit.
one of those searches.
Okay, perfect.
And I believe those had timestamps.
Big,
Okay, the
hard
links,
locals
but maybe not the
memories.
searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
He's like, I don't even know anymore.
Sustained. Lay a little foundation.
Are you aware that there was a search conducted on her house on April 13th?
On Miss Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to. She was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website, fair to say that all of those searches are believed to have occurred after April 13th of 2022?
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment. We pulled up.
Never came
Do you have
down.
that orange notebook exhibit? I can't remember the number of it.
Here, they wanna hang around.
Court's indulgence for just a minute. I have the number. I've got it.
1, 2. They've been trying to do that the whole time. It's one of their only like good attacks.
I'm
but
sorry,
they
Your
didn't
Honor.
they
It's
didn't
hard to
execute
keep
it
all
very
these
well.
exhibits straight.
The private investigator would go out to Kouri's house and look around without a warrant. He would find something that he believed was a problem. He would contact the police. They would obtain a search warrant and come look for the thing that he had kind of nodded to. That's a little suspect, right? Like, because this goes on multiple times, I think, and it's like, how did you not find these things before? And you're just kind of like, this guy could be planting the evidence. So I think that's what they're trying to get to, but they don't, and they could have done that. They would have needed another day of cross-examination, I think, and better questions. It's like you want to, it's like, can we sit down and
Can we put up exhibit 2-66R?
write out these questions for you morons?
It's admitted, Your Honor.
Her caller is trying to escape. Like, her collar recognizes danger. It's getting wider and wider as she sits. So either it's moving on its own, or like when she goes out on these breaks, someone's just grabbing her by the collared shirt and just like shaking her a bit. Like, they're like, I'm going to pretend you're a baby. And they set her down. They go, would you like a pizza casserole? Like that. Poor Kouri looks so sad.
Oh, wait, I'm sorry. Before we do that.
She's
can we
learning
put up
very quickly that
exhibit-
she's going to prison
yeah,
forever.
2-66R, that's correct. We don't have they redacted part of it, and we don't have that.
Scott, 2-66R, please.
Would he be so kind? I don't want to accidentally put something up that was redacted, Your Honor.
My apologies.
Buzz, buzz, buzz.
It's okay. One moment.
The judge's daily porn
Scott, if we
notification just
do
came
our
in.
normal dance, I'd appreciate it.
Do your normal dance. Damn. Is the court starting at 9:30 tomorrow? I assume they're going to do jury instructions tomorrow, right?
2-66R publish.
Yes, please, Your Honor.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's
One
like
p-
in an orange kid's school notebook, right?
Why would you draw attention back to this? This is bad, bad, bad evidence for your client. Oh my God. 1 p.m. for court or 1 p.m. for the jury? Those are two different things. Holy shit. This is one of the greatest pictures of all time. Aussie Overload makes it, and then we hear Wells says Nick doing pressure queen for Kouri. Whoa! Instapot, baby! You're my pressure queen! Holy shit, that's amazing. And then, of course, we have, this one. This one's good. Like, I might be able to put together this outfit if I could get this jacket. I'd say whose dick do I got to suck to find that jacket? But I'm pretty sure, like, there is a list on that run. This actually happened a couple times. Whose skull is that? I know these are the Mongolian skulls, like I reference from time to time because people have like the weird like bump head things. But they used to bind the skulls of children and make them grow up like a fucking Pringles can instead of instead of normal, like instead of like a dome shape. And they thought like the higher protruding of the skull was like a status symbol. The problem was it made them Mongolian, not just in shape. That's a real chick magnet right there, Ricada Lot. Look. If I were like, given a mission to go like as a goof, pick someone, that outfit, that would probably be one of the fastest pickups on the planet. Like, and I'm not talking about guys, like as a joke, like that outfit, you would immediately have all the attention in the room. It would do, all you have to do is not be like autistically Kiwi Farms incapable of human communication. Like as long as you're not that outfit will send you alone. It's jury instructions tomorrow. Okay, I'll have to figure out things. So I might be nice to get some sleep in the morning. But there's a couple different hearings that are not related to this case. There's Laura Owens, there's Lynette Preston, and then there's like the disciplinary hearing for David Gringus or something like that. All of those things are out there. Megan Fox has been just yapping away at me to cover them. So like if they're going to be like figuring out jury instructions and it's not televised, or there's a big break, we can do those probably. So, oh my God. I know you adore us. And there was a brief period of time where I could actually try it out. But I think, I don't know that things work out the same anymore. But that would be so fun. That'd be so fun.
Correct.
Okay, and can you fast forward, Katie, until I tell you to stop?
Go pick up
Keep
a woman at a Buc-ee's wearing that. Okay. Like, let's do that. Buc-ee's is open 24 hours. I'll just stay there until it happens.
And can you blow out the bottom third of the page? All right.
So this orange notebook. that
Kurt
was
Killer's
recovered
trial
from the
won't be for a
house,
little bit.
You don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death.
Hey, real quick. Hold on. I think we just got a donation on Venmo. I'm trying to see if there's like a message attached to it. You'd rather chill in solitary, to be honest. It would just be for the, like, it would be fun for the meme, for the show, like, for the outfit. Like, holy shit. What a silly thing to wear. So the jury isn't coming back till Monday morning. Okay, so it sounds like tomorrow they will come in and start arguing jury instructions at 1:00, which is nice because that'll, the judge is giving them time to get everything set up. Thank you very much, Adriana B's Custom Furniture, for the very sweet donation on Venmo. Really, really appreciated. Thank you so much for that. Okay, here we go. Let's see how they can just draw attention to bad evidence for their client again and again and again. I want to see their strategy for that.
Right?
Correct.
All right, and here on there is an entry.
I haven't used my
that
Instapot
says on
since we
March the
started
22nd.
really covering
Can you
Kurt.
highlight that, please, Katie? Kouri starts counseling. Do you see that?
Mm-hmm.
You need to say yes.
Yes,
Okay.
sorry.
Did you take any
on.
steps to verify if that actually was the date she started doing mental health counseling?
No, who cares?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if a mental health counselor was part of those, but that's possible.
And I imagine as a
You imagine. That's I can only
I
imagine.
forgot the word you used. As a serious crime
those chicken
investigator,
strips.
homicide investigator, detective, death scene investigator, you've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with
think I
victims
met
doesn't
that
usually
guy.
go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
How much does the average murder trial cost? All wages and expenses, and who pays the bill for it? I'm guessing the taxpayers as usual. Well, when it's the state versus a public defender, yeah, both sides are funded by the state budget. Rumor has it in this case, Kouri Richins' defense has cost about $1 million so far, something like that, or maybe they flat feed it out as $1 million. That probably covers their expense budget as well. Karen Reed's was $5 million, but these aren't average murder cases. Average murder cases are probably 2 to 4 days long, like 4 days long, maybe with the jury deliberation. But average murder cases involve, typically someone associated with gangs or drugs, shooting someone, and as part of the gang or drug activity, someone seeing it, like 1 or 2 witnesses just say, "Oh yeah, he had to ice L dog or whatever, took that L hard," and that's it. So those trials don't cost that much. They don't take that long. There's one or two solid witnesses or like closed circuit television footage that clearly show the murder, and then it's done. Those people don't have a lot of money to fight. They don't have a lot of like personal resources that are, and by that I mean other people who are going to come in and like testify on their behalf and try and do the character shit. They're going to prison probably again. And that's the overwhelming majority of murder in the United States. It's related to that type of activity. $1 million for this. What the fuck happened? Did she eat the money? Remember, it's 3 attorneys. They have a whole lot more work that they do than just trial. The attorneys, we can find out, actually. Here we go. Oops. Give me just a second. Let's find out roughly how much these counsel are per year or per hour. Utah appointed counsel murder fee agreement. Okay, so lead counsel. Oh man, these guys actually get a good rate. Lead counsel gets approximately $200 per hour, with maximum fee caps around $175,000 for a capital murder case. Second chair would get $160 per hour. Now, those are not good rates for capital murder defense attorneys, but those are good rates for appointed counsel. In Ohio, for example, appointed counsel, now not on a capital murder case, but on a regular felony case, the appointed counsel gets like $55 an hour with a $5,000 cap. So in this case, you're going to have a couple lawyers with the cap around $150,000 to $170,000. That's going to take up close to like 45% of the budget. The rest of the budget is going to be paying witness expenses. It's going to be creating audio, video, visual materials, hiring experts, stuff like that. Yeah, $200 an hour is super cheap. But as far as appointed counsel getting $200 an hour, that's actually that's pretty good for them. That's a lot of states. In Minnesota, it's like $50 or $55 or something. I never did it because I was like, are you kidding me? That's not enough money. That's not enough money to do this.
I'll move on. I'm done with that.
Are we approaching or moving on?
Well, we're moving on from the subject matter. No need to approach.
Got it.
We are moving on from the subject matter.
Very good.
All right. You also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you.
Do you want to put those
that
chips
Carmen
in your
had
mouth?
placed Mr. Richins' obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it. Yeah, I mean,
Okay.
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit? Yes, thank you.
You're the only
The second
one.
one, 816R, I think.
Through thick and through
Oh, it's
thin.
15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Yeah, Captain Cocaine
one's got
would look like a
things
Would you
fucking
help us out?
ghoul.
Thank you. Let's see. This is 8
Not be eating that sandwich.
Let me just make sure this is the one you intended, Ms. Nestor.
That is the one.
And Judge, Katie does have this one if you wanted to switch back.
Okay.
Yeah, because I'm going to need her to blow it up. Can we
One
switch it
moment.
back to her, please? I'm so sorry.
Yeah, me too.
There was a recent version where they blurred a lot of children's faces out and stuff. Okay. Do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it? Or right
Skinny
under it?
version was just sad.
Do
He
you
doesn't
see
know he's supposed to be sad.
Another In loving memory, right below it.
Yeah, it looks like a
So some Ting Wong says, anyone think this man would commit suicide with his kids present, according to the defense theory? The defense specifically did not put forward the theory of suicide. When asked about it, they said, no, we are not claiming suicide. They only put forward the theory of either an alternative killer or accidental death. They said no suicide. Eric doesn't have any of the hallmark signs of someone at risk of suicide. He doesn't seem to have a history of serious suicidal ideation, at least that they elicited as testimony that I remember. Maybe I'm wrong, because that could have been kind of boring stuff, but I don't remember that. The closest thing they got was a statement where he basically said, yeah, if I die, like, you guys are going to be taken care of for life. So I don't think we have any of that evidence to go off of. What I would say in response to the question, though, is by all accounts, he seemed to really care about his kids. And yeah, I think he might not do that way. Like, why wouldn't he just drive like up to a nice like hill or something that he really likes and chomp the fentanyl down and then die in his truck? Men don't. Here's another. They should have brought in an expert on suicide. Well, they didn't, but they weren't fighting over suicide, so I guess that's why not. Men don't tend to use pills for suicide. Men tend to use a gun. Like, that's how men tend to do it. Pills for suicide is much more common with women. Pills for suicide also, fentanyl is effective, but a lot of pills that do get taken for suicide, thank God, aren't effective. A lot of times teenagers and stuff that using pills for suicide is a call for help rather than an actual attempt. And they take something that's like, oh, there's just a lot of these pills, they'll probably kill me. And a lot of them won't. They'll just make you really sick, and there'll be plenty of time to like pump their stomach, and it could cause some harm and stuff. But fentanyl, of course, will just win. Random unbreaded commenter says there was a coke-powered DC villain, Snowflame. Oh, that sounds fun.
program pamphlet from a funeral.
Okay. All right.
Any not guilty votes in here?
Also, the C&E hat, I believe.
I think after today's lack of defense, like we're seeing the end of it, but day 12, I think by the end of day 12, when the walk the dog letter came in, very few people are on the not guilty side. And I think that letter buries her. She's done. I don't know how they're not going to get past it. I said the only way they could is if she took the stand, and they didn't have her take the stand. They didn't mount
That was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. All right.
So the problem with this, Success in the 80s says, I feel like she should have argued he was an addict and in pain, so she gave him fent, but it accidentally killed him. Might have gotten a lesser sentence. The problem with that is the walk the dog letter suggests that she knew about his addiction and did not approve. So she probably wouldn't have fed it, and that her brother Ronnie would remove the pills to hide them from her, and he would stash them, and then Eric would, get them the next day or whatever. In the walk the dog letter, she was instructing her mom to instruct Ronnie to tell that story to her then counsel. She would have run into a conflicting idea at that point. If the walk the dog letter doesn't exist or doesn't come in, you could try something like that maybe even bring Ronnie in to do it. But if they brought Ronnie in to tell that story, the walk the dog letter comes in. So, there were just problems. The problem is she killed him like that. At the end of the day, when you're watching these trials and you're like, whoops, you're like, God, there's just so many, there's these problems. And, it seems like there could be some way to overcome them, but you're just struggling to figure out what it is. And all of those solutions involve, facts that just don't exist. The reason is because they did it. The reason is because they fucking killed him so often. Ask Gilly says, how fucked is it that people who are arrested for selling drugs and also happen to be exercising their right to keep arms are charged with simultaneous possession? Scale of 1 to fucked. I think it's pretty fucked. And I do think that possession crimes that involve the possession of a firearm, not the use of firearm and possession crimes, weird, but like a sale crime that involves the use of a firearm is one thing, right? Like it's going to be 10,000, not 8,000. That's a big deal. But possession of a firearm while also selling narcotics or whatever. Well, for one, I just don't think drugs should be illegal in the first place, but we'll accept that they are. I just don't see anywhere in the Second Amendment where it's like, you can own guns, well, unless you're selling drugs. That doesn't make any sense. In fact, just having a nonviolent felony take away your gun rights doesn't make sense either. But in my case, for example, one of the problems they were going to face on the gun crime, and they offered to drop the gun thing right when we start negotiating. They're like, the kid stuff and the gun stuff, we're dropping that. So just to start off the thing, don't have to worry about it. Okay, cool. Like they had problems with the prosecution of those things because while there were guns in the presence of, or like not in the presence of, how do I word this? There were guns in the same house as narcotics. They couldn't ever prove that the guns and the narcotics were in the same place at the same time. They didn't have testimony of the snitch didn't testify that he ever saw like guns and drugs at the same time because he didn't. They didn't have any testimony like that because it didn't happen. I can understand criminalizing like a mind-altering substance plus a gun. I don't know that I 100% agree, but like those laws are common. They make logical sense. But just the mere simultaneous possession doesn't. What about this makes it a crime? Anyway, sorry. It's late, so my answers are getting longer and longer and longer. Muppet Angela says, Nick, is all the addiction and drug talk bothersome to you? No, not at all. I find it really interesting because one, it's like I'm going to get pilloried on how I word this no matter what I say. It's a safe way to engage the things that I remember and liked. Like it's a safe way for me to do it. It's a healthy way for me to process through that. So I don't mind it that way. The other thing is, one, while I was using, because I wanted to be as safe as possible and also maximize experience, I started researching quite a bit and I learned a ton about them. And then of course, when charged with a crime, you research more and more and more because now you're trying to figure out for your defense and getting prepped for that. So I did all that research. I know all this stuff. I had all these experiences. I don't want that to go to waste. It could be valuable to other people, either for curiosities. It could challenge some of their perceptions. It could give them ideas if they have to fight like against those charges or whatever. So like I enjoy the subject. I think it's interesting. The one thing that concerns me about it is that it'll give like it gets too much for other people. But I really haven't gotten too many complaints about it. I try not to make it the subject of the whole thing. But I like I had to take a crash course in all this stuff and learn a lot about it. And it's also something that a lot of people will never try, which is good. They shouldn't, but they might want like someone that I won't say you trust me, but someone who they can at least trust the descriptions of. Explain it to them. Because like you can read about it in a book or someone else online, but you guys know how I communicate. You can like build a communications profile by watching my show, and then this happened because it was national fucking news, I guess. So you know those details. So then you can go, okay, well maybe I can trust this as an accurate description of experiences and stuff like that. It's a safe way for people who will never try drugs in their life to engage their curiosity about it, I think. And the final reason I talk about it is really straightforward and really simple. When I started talking about it, when I first came back, I talked about it a lot, and I got a lot of shit from really close friends. They're like, you got to just move past this. Don't talk about it anymore. Don't remind people, blah, 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 blah. You got to work on your image. And I got a call from my licensed drug counselor who did my chemical use assessment. And she said, thank you so much for talking about, candidly about drug use and addiction and recovery. Like, please keep talking about it, because the resources that are out there, people don't connect with them, but they can connect with you and they can know your story. And so how do you stop after that? That's someone who's been helping people with drug addictions for, I've known her for a long time. She's been helping people with drug addictions for 22 years. And she says, please keep doing that. It helps and it matters and no one else talks about it. Well, then you got to do it. You got to do it at that point. We just got 5 gifted memberships. I forgot to see who that was from, so give me just a second. I'll go back to that. I put the window away, which is very, very rude of me. But that brings us to 10 gifted memberships. That was Cat Black 184. Thank you, Cat. Very much appreciate that. Okay, here we go.
I also want to show you a text.
Iceman says, Nick, no one could get you to stop anything. The best way to get you to do something is tell you don't do that. I know. See, I'm very manipulable that way. Very manipulable. Muppet says, Nick, my late husband was a recovering addict for years. I just want to be sensitive to people, but yes, thank you. Yeah, I talk about it candidly because it happened. I have no desire to contextualize it or minimize it. Like, it happened. I'm happy to tell you pretty openly now about it. And part of that is because I don't have a moral conviction against drugs at all. And I believe they should be legal. I believe that we should be able to make even bad choices for ourselves. I'm not saying that would have been a good thing. That's my personal opinion. So I'm not ashamed of it. I didn't like getting caught. I don't like the results of it, but just the in general acts of it. I've never had that. I believe we have the liberty to make mistakes and to learn from them on our own rather than have the government do it for us. And that's consistent with my worldview on everything else. So you know what, fuck off government is always my thing, but I have these experiences. So I'll share them. I'll share them if they help other people or if they entertain other people.
As part of your investigation.
Also, we saw it. Lying would be so gaslighty. Last thing on this subject, because we got to get back to the video, or we'll never get through it. A lot of people say I lied at the time because they would come on and they would ask me to admit to doing drugs, whatever. I wouldn't do it. I wouldn't admit to it. And I would tell these micro truths I don't really like cocaine. No, I don't do it. At the time, there's true. I had bad cocaine. I liked Molly a lot, though, and was doing that with regularity. But I didn't really care that people knew I was doing drugs. I just couldn't have an admission in public because cops will kick your door down for that stuff. So like, again, I don't have a moral opposition to it. It didn't bother me if people knew. I just I couldn't go out and have that statement. So some people are like, you lied. And it's like, I mean, I guess, but what I mostly did was not answer or dodged or, address part of the question. That was the main thing. But it's like, I wish I could have just said, yeah, I am. It's not a big deal. It was a big deal, but that's what I would have said at the time. I wish I could have just said that and not been at risk for legal ramifications, because it would have made everything easier. All right, here we go.
Of reviewing texts between Eric and Kouri. Katie, if you could pull up Exhibit 2 dash, I believe it's 9.
Difference between me and
2-3.
Nerdrotic.
Thank you. That's it.
A lot of time, different style of messaging, though. I think Nerdrotic basically said when he talks about his experiences, and I'd have to go back. I interviewed him on the show all about it, and but he's pretty consistent that it's his experiences were universally bad. They're full on lesson for people, etc. And so we have a little bit of a different discussion. And then there is a significant amount of people who believe this stuff about my kid, which I don't know how to ever address that, because it's like that's insane. But what am I going to do? Like, I can't prove a negative. There's nothing I can show people to change their mind. So it's just time at that point. And I will maintain that to the end of time that didn't happen. I would have loved to know what was going on with the test. I would have loved to figure it out, and they didn't let me. Not much I can do about it. But there's nothing I can do to change people's opinion on that. But that's the big thing. And there are a couple people who lied pretty heavily about suggesting that there was use around the kids. But when they, gave their interviews to the police, they said different stuff because they weren't doing a marketing campaign.
Before you look at that, do you recall trying to investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
All right. And did you?
Muppet Angela, I said I was going to be done. One of the most frustrating things is that the fight over the body cam footage, because there is private stuff in the body cam footage, it just doesn't belong in public. Where my kids sleep, stuff like that. Because people fought so hard for it, it closed off my ability to utilize portions of that footage in the way that I'd kind of had planned to put together something that showed people what happened. Because you just put together this is my best case, my best idea of how this worked out. And I would have loved to do that. But once the body cam footage became contested, it became critical to not release any of it, not even a snippet, because these people were, they would say anything. They would say that the release of even a single frame would require the release of more contextualized, and you might get a judge who agrees even temporarily and stuff, and that just didn't belong in public. So it really crippled my ability to address some of these concerns with the evidence that I do have. But that might change in the near future as they keep losing their lawsuits, and those will close out at some point. 8G to see your underwear drawer to have a qualified opinion of your innocence. I don't wear underwear. There's no underwear drawer. Will I do drugs again? I can't even think about that. I can't put myself in the headspace of that, because that's how you start to get into those like temptation cycles where you're like, well, you know, blah, blah, blah. I'm not making that decision at any point. Right now, I don't have any intention to at all. Right now, I have years of probation to deal with, and that's the priority for everything, because I'm not going to go to prison. You know, I need to be around for my kids and stuff like that. So like, there's no, I can't entertain those thoughts. So with that, you know, probably not, but I never thought I would either, but I don't plan to. Iceman says, jumping off my previous comment, Nick, never ever seek out JD Delay, and especially do not have him on your show. Never ever. Okay, I'll never do that. Now TMI with the underwear. I still wear clothes. Like I'm not hanging out. I'm still covered. It's just more comfortable. Yeah, my probation is 5 years, but it could be over sooner. We'll just have to see. Again, can't sit around like thinking and waiting for stuff like that. You got to just work on other things. Part of the reason I dress ridiculously now, I say ridiculously, like, you know, part of the reason I dress the way I do, and I started, it's a new hobby. Like, I needed a new hobby. I didn't have cocaine. I didn't have scotch, and I didn't have like going out to like clubs and stuff like that. I didn't have that anymore. So I needed something to do. Well, this is a very fun hobby. I'm learning new stuff and having a good time.
You review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had. I guess it depends on the timing that you're asking about.
Okay, I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you looked at in trying to make that determination, okay?
Okay.
Can you blow that up? It's Exhibit 2-3D as in Delta.
We had a really strong foundation, Kat. I don't know how other people would do it.
And just let him look at all of them, please, just slowly. Give him plenty of time to read. Can you go back up? I think,
Askeles, I said earlier in the stream,
that one,
I'm not
great.
commenting
Next
on
page.
it. He should be living his life. I don't want to be involved in that segment of the internet.
Does this refresh your recollection? Do you
working
remember
to,
looking at this
keep
set
out of
of
it.
texts
I'm gonna just go ahead
between
and keep
Kouri
that
and
strategy
Eric?
for now.
No, I didn't have time to finish reading that.
Oh, sorry. Keep letting him read it.
Nicotine's the hardest one to quit. Started smoking, quilting opiates, and, well, I still vape. Oh, quitting opiates. I've never had a problem putting down the vape before. I don't know now. It's like one of the, you know, you get used to always supplementing yourself with liquor, at least. Is a vape's a nice way to do that. That's not crazy. So who knows that? But I never used to have trouble with it, and I lose them all the time and don't care.
Okay.
Does that refresh your recollection? Do you remember reviewing this series of texts between Kouri and Eric relating
And I don't
to
ever
the
mean
trust?
to minimize like other people's
I
struggles.
don't
It's
remember,
just-
and the context of those messages,
A
I
lot of
can't say
times
that that's what they're talking
I
about.
don't.
Okay, so this does not refresh your recollection.
No.
Okay, court's indulgence for just one moment, Your Honor.
And if anybody's curious, it's now 332 days since my last drink.
Your Honor, may I approach
charged in states.
I say it because you gotta keep track, or well, you don't have to, but you do keep track. But I don't say it in the same way as someone who voluntarily quit. I do think that's a different animal, and I hold those people in a little bit higher regard. They're making a choice for their life, and go for it. I mean, mine I'm incentivized really heavily not to do it. You'll go to prison. It's been 300 plus days since she killed her husband. We had those drinks. No. Thought it was over a year now. Nope, it was April 15th was my last imbibing of alcohol. For anybody who gets worried about that, I was sentenced on April 18th. Prior to April 18th, I was on unconditional release with no restrictions, no testing, no probation requirements or anything
working on
like
something, but I'm going to ask a couple more, move
From
back, and then we may come back to
mid-November
it when she's done looking.
through April 18th.
So
Then I was
it your understanding,
then I had my
without
plea and my
saying
sentence.
anything anyone told you, when you were conducting your investigation, did you become aware that
I do want to say one more thing. If someone asks if I'll do drugs again, not planning on it. I will probably drink again. Whiskey was a hobby of mine. I like it. What I will not do, likely, is drink on my show. That was a bad plan. It worked out really well for a really long time, but you know, like having a glass of it, like a reasonable adult handling alcohol in a reasonable way, sure. Like I might do that when I'm off of probation and everything's good. Bringing it on the show brought me way more problems than I ever wanted to admit at the time.
Kouri knew of at least some portion of the some aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation.
Right now it's the
otherwise
voodoo
based on hearsay.
great Lichonsky.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it, there may be some foundation here.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled based upon.
Catman, you're way better legal explaining. Yeah, at first I was annoyed, right? Like I was afraid. No, I was annoyed by it. It's hard to figure out how to do a show when I've been doing it that way for so long. But once I hadn't been following legal stuff and political stuff. Once I got back into not with the Karen Reed trial, but when I came back after the Karen Reed trial, so about a month and a half after Karen Reed, I noticed like it took a different style of prep for the show. I couldn't just rely on the social lubricant aspect of it, but I was so much clearer on things that I remembered, on applying legal principles, on remembering cases, on predicting what was, going to happen soon, like looking at strategy. And you just didn't, at the time, just couldn't see it. You couldn't see, or I couldn't see like how much it was affecting me. So that's been really nice. That's been really cool.
On his prior answer, you can answer.
Oh wait, I need to take a picture of this fatso for the thumbnail. did that wrong. Thanks, me. Okay. Here we go.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right. Now I want to talk about Valentine's Day. You were here when Ms. Staking testified to the jury that in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor, foundation. That's not what happened.
I think your
Getting
recitation
wrecked.
of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay. Did you become aware that at least in some context there was a discussion on about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Ms. Staking, from my memory, testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay, so did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor, is that correct?
Yes.
You're actually going
And
to be moody?
he had an EpiPen
About
device
what?
in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether
TB says, I'd rather all the money go to you rather than only 70%. I really appreciate that. Thank you. That's really, really helpful. One thing I'll say, though, super tips, supertip.gg/RL, only takes 90%. They take 90%, not the 30 that YouTube takes. So, wait. They only take 10%. They take 10%. I get 90%. I said that completely backwards. They only take 90%. They take 10%. YouTube takes 30. So that's another option as well. Malcaron says, remember your whiskey suggestions from a while ago. Finished my whistle pig. It was great. Working on the Angels Envy finish rye at the moment. Ave Dominus Nox. Ave Dominus Nox. Back to you. And that Angels Envy finish rye, I still maintain, is the best $100 bottle of whiskey that you can get, that you can get everywhere, type thing.
Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to
Probably going to run a special on
avocados or wheat or
locals
peanut
membership
oil?
soon.
Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies.
People are enjoying the locals chat.
Trees, grasses, dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital.
And
So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
were you ever able to confirm that he did?
No.
Okay.
And if I do a locals special,
All right,
I'll
I
probably
want to also talk
do a special
to you
offer to
about Miss Susan
YouTube
Kohler.
members.
Do you know who Susan Kohler is?
that's
Yes.
Who
separate.
is Susan Kohler?
She's an associate of Carmen Lauber's. She worked for Doreen Kouri cleaning houses with Carmen Lauber.
Okay. And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold
T-Dog, I've talked to Andrea several times since my pending comeback and my like full return, and she's always been very kind and has said that we should put something together and do it. It's just we're just both busy. My understanding, she was always, like you said, she never said anything negative. I think she was very happy to see me kind of pull through on the other side. And I love her. She's so fucking smart, and she's a badass. And so I definitely want to do, shows with her again. We talked about doing something during Karen Reed, but then my schedule with Karen Reed fell apart. Same thing with AV to the Seventh Power. I like both of them a lot, and they've both been very, very nice to me. So, are very kind and understanding. So, definitely collabs
I think
in the
number
future.
was 15 to 20 Roxy's or prescription
Aunt Clara.
narcotic pain pills to Carmen. You
can always find a sharp-dressed man here.
Okay.
From probably now on.
And was Ms. Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis?
Lay the foundation.
Or do you need to approach?
Relevancy.
Approach for 1 second.
TB says, I thought YouTube took 30%. YouTube does. The really scary thing is if you do a YouTube super chat from an Apple device, Apple also takes 30%. They end up taking 49% between the two of them, I believe. And so on a $10 super chat from an iPad, the creator gets $5.10, which I think is crazy. AV would be a great guest. And I want to bring back lead attorney. That man is a fucking gem. He's so funny. And I haven't talked to him in a long time, so. But I want to be very clear about one thing.
The relevance objection is sustained. Ms. Nestor, please proceed.
Despite the YouTube cut, I love, and I think the YouTube cut on super chats is unreasonable because I don't think YouTube is providing 30% of value in a super chat. On gifted memberships, though, I think that's a little different, and I actually don't mind on memberships and gifted memberships. I don't mind that cut because people get so much value for the same money as a super chat. They get access to the member content and, having the naming in chat and their custom emotes. I'm going to redo those. All this stuff is, on the docket, but baby steps. But yeah, so there are things that you get directly tangible for memberships. That's why I push them so hard. I love seeing people brought in. It brings more energy to the chat. It brings more energy and more people to the members only stuff, and it lets that be a lot of fun. I see people stream to 2 and 3 and 15 members, on their members only stuff. Our members only stuff is 600 people. And it's fucking awesome. It's a lot of fun.
Did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
Sunderberg, he does.
We found a bag
Lead
of
attorney
loose,
does.
I believe they were hydrocodone pills in the mudroom walkway cabinet in the house. They were tested. They did not contain fentanyl.
Thank you. You also testified, I think, yesterday that shortly before Eric passed away, he went on a hunting trip to Mexico. We talked about that a little bit, right?
What's up, Ben Ramler?
Yes.
Thank you. Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records, as was demonstrated by Mr. Kotromidis.
I love how she just keeps asking him about other people's testimony. And the reason she's doing this is because defense has realized that they really suck at cross and they have issues that they need to clean up. And this is their last chance. So they're asking this guy about other people's testimony. The reason they're trying it is because he was sitting in the room for pretty much the entire case. As the lead investigator, he gets to do that, unlike other witnesses who are sequestered away from the hearing until they're called in and then released. So he's been there. So they're like, you heard this. This is what blah blah blah, and he's just answering very calmly, like, hey, that's someone else's testimony. And that may be what they said, but you'd have to ask them any other questions. But they need to rehabilitate some of these witnesses. They screwed up on cross so bad. They left things out. They asked bad questions. They got bad answers. And they're trying to fix it through him. I don't think it's working. But it's a good shot.
And
State's just letting him go too because
reviewed the phone calls.
it's not damaging at all.
Well, strike that. I'll strike that, Your Honor. Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up. All right, we're almost done. So just to recap a couple of days of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
Gaming chat. So just curious, what do you mean by this statement? You can see why Rickade isn't practicing law in courts anymore. I mean, I know exactly why I stopped, very intentionally. But I'm curious what you see.
There were 10 search warrants issued, yeah.
And
Or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
Well, they have investigator, right? She testified here.
Yeah.
Okay.
They're a civilian investigator.
Fair. Also,
Is it
there was a
fair?
private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
Who cares?
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that,
What are you doing?
we have no murder weapon. Like, you haven't found.
You dumb, fat idiot. What are you? We have no murder weapon. Fentanyl pills that are in the stomach. The murder weapon actually was in the stomach goop, waiting to further kill him if he didn't die. Holy shit. Like, the juries aren't always smart. But they're not this fucking stupid. That was crazy. That is a crazy, crazy question to ask. We don't have a murder weapon. He died by a digested substance. Why? How do you dare unironically suggest that?
Anything that was connected to Eric's death? No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach.
There it is!
With him.
Other than this, what's in?
Why would you ask that question? If you have a cop this cop's sitting there thinking, he's got a little snark. There's a boatload of fentanyl in his system. It literally, like if they scoop it out, it's a smoking gun.
In his stomach? Did you find anything else that had fentanyl in it?
No.
Okay. You can't say how the fentanyl was administered, right?
Orally.
Besides orally.
That's all I know is that.
Brutal, by the way. Like, it's not a big reveal or anything, but she's saying, you can't do this. And both times he's had an answer. Shredding her own credibility like a block of mozzarella. Getting sweaty. Needing an umbrella to stand near this planet.
He took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Holy shit, she's getting cooked harder than the panini she's about to cry herself to sleep on. Illicit fentanyl doesn't come in dosages. Half the defense's case was like about trying to nail down these dosages. Half of the is these 30s. That's 30 milligrams of this. It's not really fentanyl. And he just says, fentanyl doesn't do that. He just torched the work they did on the amounts related to the pills. Fucking dumb. No reason to ask these questions. This testimony would never have come in. We'd all be sitting there going red 30s or what, like blue 30s and red devils or whatever it was. Sitting there thinking of that, going, how much fentanyl is in that? How many of those does she need? And he's just like, yeah, illicit fentanyl doesn't come in doses. Like, what are you talking about? Just lit it and burned it to the ground. Well, the other crazy thing, though, is, I mean, illicit fentanyl can come in doses. There's nothing stopping it. There's nothing stopping someone from pressing out fentanyl pills in like 2 milligram tablets or whatever. But it doesn't matter. This guy's a narcotics
You
detective.
can't say what was ingested on Valentine's Day at all, correct?
Fentanyl was definitely ingested. Oh, sorry, on Valentine's Day.
Yes, on Valentine's Day.
Can't say what was ingested on Valentine's Day. Fentanyl was. Here's another subtle dig. And this guy's doing this important. This guy is doing this very intentionally. One of the defense's strategies was to try and paint the investigation and the prosecution as if they don't have an official cause of death. Because the coroner could not, with the information that they have, rule it a suicide versus a homicide. They didn't have an official cause of death. And we heard that at opening argument. Like, you don't even have a cause of death on the death certificate. And then, of course, toxicologist comes in, or the medical examiner comes in and is like, there's 20,000 nanograms per milliliter of fentanyl in that stomach just waiting to murder him more. And we're like, oh, well, then there is no ambiguity. There is no confusion at that point. You know it was fentanyl. How much does he have in his blood? A 13.5? 13.5? That kills minorities even. Like, whoa, that's a lot of fentanyl. Like, holy shit. Sorry. Not that sorry about that. That's a lot. And then you've got this huge amount waiting to be digested, filtered through his liver, and kill him more. And she says, you can't say what was ingested. Fentanyl was. It's over and over and over. Bam, bam, Bam. We know the fentanyl killed him. We've measured the fentanyl. The one thing we've measured, we're not finding evidence of those gummies. Like, we're not finding that THC problem you keep talking about. We are finding a fentanyl lump. We are finding a fentanyl Puerto Rican hiding inside this man's stomach, waiting for him to break into the U.S. and he'll break his way out.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
He just answered that sarcastically? Fuck. Whoops. Ari says, I'm telling you, she has to be trying to help Kouri by being ineffective at the beginning. Ineffective assistance of counsel is so hard to do. Like, just being bad at your job, missing things, falling asleep, sometimes even showing up intoxicated has not been sufficient to render someone as having ineffective assistance of counsel. You have to so categorically fuck up. And not just do poorly. Like, you have to miss requirements. It's crazy.
On insurance fraud, we have not heard any testimony about any representations that Kouri Richins made to her insurance company. Have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach her?
To be fair, AJ, there's no way this defense attorney was going to do anything other than tank. She's certainly not DPS. No way is she healer, and she has no magic left in the tank. So, or left in the, in the receptacle. Like, she is, and she's big.
One second.
I'm a fucking nerd. Yes, I'm okay with it. You just don't... Guys, if you're really concerned, like you're a nerd, it's causing you trouble, you're not getting the attention, the type of attention or results that you want or whatever, just don't let them know until you've roped them in. Once she pulls out that test, it's like, I'm pregnant. Be like, ha ha ha, I play D&D every weekend, bitch. Just do that. But don't tell her beforehand. It is safe to be a nerd. You just have to trick women. Ari, I think she's ineffective counsel, but as far as like the legal standard for getting ineffective assistance of counsel as like an issue, like as an appeal issue or a vacated judgment or directed verdict, like, or a mistrial, I guess, main thing, a mistrial. She doesn't meet the standard.
State's objections are overruled. If you would restate that question, if you can, exactly.
I will. And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name
Objection,
on
that was a legal conclusion.
documents as a married couple?
No, but that's still signing someone else's name, even if they give you permission. Purporting.
Just because husband and wives do sign the names, like I don't. First of all, Lady Ragged's handwriting is way nicer than mine. And second of all, I always change up my signature so she can never, like I don't try. I'm just kidding. I don't do that. But she wouldn't. She would just talk to me if she needed something signed or like needed authorization. Like we just work it out because we're at that stage. We're going to have to sign each other into retirement homes at some point. So we're at that stage. We just ask. Some people do it. Just because people do it doesn't make it like ever actually not a forgery. It's still a forgery. It's just some people might not be offended by it. Here we go.
It to be somebody
I
else's
had something
signature.
else.
Okay, well, the judge is going to instruct the jury on what the law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection.
A limited
No,
power
well,
of attorney.
Not objection. May we approach?
Sure.
Thank you.
There's a limited power of attorney, and I think he determined that she exceeded the limits that were supposed to be there. She's got to be wrapping up. This chick is thinking about
Did you hear him
chimichangas.
say Throck? Okay, I'll withdraw that question, Your Honor. And you were here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was probably
Not Eric,
probably not Eric.
but he
So the crazy thing about this is asking these questions. State's not objecting to all of the things, and I don't think they give a shit at all when if she wins a particular objection or not. This one she didn't win, right? She withdrew the question. She asked something different. The state doesn't need to object most of the time because this guy's answer allows the lead investigator who determined she was guilty enough to send this to, either the attorney or grand jury or whatever. This guy who believes he cracked the case and definitely believes she's guilty, you're asking what prior witnesses said to his recollection. His recollection is going to skew towards her being guilty because he's thought that the entire time. He's thought that since the Bible was still a sperm in God's eyes. I don't know why he keeps sperm in his eyes, but he is the Lord and he has special talents that not all of us do.
could not say that it was signed by Kouri, correct?
Correct.
Okay. I think that's it. I appreciate your patience. Thank you, Detective.
Oh,
Thank
my
you, Your Honor. We
gosh.
tender the witness.
Mr. Bloodworth, within the scope of cross, please.
The state should just be like, fuck it. There's nothing else to ask. I mean, they're going to. They tend to like to ask at least one question. Just to assert that the defense is dumb.
Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part
Him and Morgan
involve
Wallen.
coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
No, I can't know every single detail. It's, as
Guys, please hit the like
defense knows, terabytes of information.
if you're liking the show.
And in early
Especially if you're liking this time slot and
2023,
stuff.
was your personal investigative focus on determining
More night
the
shows
source of
are
the
coming as
fentanyl
the
that caused Eric Richins' death?
Trial schedules changes.
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Kochodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you
It's
say?
that time of the school year,
2023.
Sparkles.
They had a little. I mean, how early? Not until March and April.
Well, let me ask you this.
January, 0.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard.
Did
I thought
you
you
say
said
forensic
digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
Did the county attorney's office become involved in this case in early May of 2023 when it charged Kouri Richins?
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Kochodimos and Ms. Carrington?
Yes.
And is Mr. Kochodimos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
Yes.
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway Mansion?
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked the sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber that she was something like the biggest piece of the puzzle?
Bro, Sparkles.
Yes, I remember
it's
that.
so
What was the
bad.
context of that comment?
She said something about, can we just lay out all the information, all the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know.
And
She
did-
had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline
Correct.
of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
I
Yes.
agree.
And did
We
it,
didn't even get into
Catman.
that until well after.
and did it predate any of Mr. Kochodimos' investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office, was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundations.
He did. He asked, did you recall this?
Do you recall what happened with the empty 2016 hydrocodone bottle?
Made my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
just here to this building.
To this building?
To
or
meet
this
with prosecutors or
Catch you
talk
later,
with her
Matthew.
attorney. They're here.
Thanks for hanging out. I put up a poll in the YouTube
Can
chat.
investigators force
Please
someone
check
to,
it out.
anyone to speak with them if that person does not want to speak with them?
No.
Can investigators seize someone's cell phone without a warrant based upon probable cause?
No. It has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
The GIF image, the one with Kevin Spacey that says idiots, idiots
DC killing
everywhere.
spree.
Is
I
that from the
agree.
TV show
Or, well,
House of
that's what I've heard.
Cards?
From my understanding, yes.
Thank you.
Random. I don't think I can do polls on Rumble, can I? Okay, I should. I'll check. So when there's not a trial, I plan on, like, not necessarily 8-hour shows.
I'm sorry, is he finished?
Who knows? But
We
I
have
plan
no
on
further
doing
questions. Thank you.
May we
more
release this witness?
daytime
Yes, Your Honor.
streams.
Mr. Bloodworth.
You know, as
Yes, Your Honor.
More
Detective
daytime
Driscoll, you are
streams as
free to
I
go. You are released
go.
from any subpoena.
Thank you.
Thank you,
and
sir.
YouTube has not been. They're just
Mr.
been
Bloodworth.
unforgiving.
Your Honor, the state has
On,
a stipulation
regrowth.
to
So
admit. I don't even think we have to publish it, so if the state could, I think we've marked it as 865.
hoping that
We'll
maybe Kick would
admit
give that
now.
Okay.
a change. So might be
Can I
trying
see
that
it for a
out.
moment?
But I don't plan on taking trial streams away or anything like that. That would probably be, I'd probably add Kick to the platform. But I heard Kick has a lot of extra features and stuff like that. Your SIGA streaming services
Please.
won't watch Kick or Twitch, won't give Rumble money. The only reason you pay subscriptions on YouTube is because it's already connected to my Google Pay account. Google,
Do you want me to give the emoji
YouTube
stick and
has
stipulation of
locked that
fact
in very well. That's true.
preamble and read this to the jury? Or do you want to just admit it?
Your Honor, I think if we can just admit it now, during jury instructions, when the court would instruct on that, we can read this.
All right, we'll have a
DC Killing
discussion
Spree.
about whether to convert this
There's
into a
something about being
stipulation of
partnered
fact
on
instruction
Twitch,
when the time comes.
Kick
Thank you.
and multi-streaming. I just got to learn
State's
about it.
Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties. Mr. Bloodworth,
Your Honor, state's in an interesting posture.
do you need a moment on the record outside the presence of the jury?
We do.
Okay. I think this would be an appropriate time to just set a schedule for the rest of the day. Are we going to be able to, it seems likely to me, you tell me, that we'll be taking a recess now but not coming back for about 90 minutes. Does that sound about right?
Your Honor, that's my sense of it. I'm waiting on a defense decision.
Okay. Well, in either way, I'll bet you a steak dinner it's going to be about 90 minutes, but we're going to rise for the jury, and I'll send out word through the bail.
All rise for the jury. It's a lot of stakes.
We have lunch coming today, right? Okay, very good. That's fine. I just think they appreciate Ellie.
Yeah.
Have a seat, folks. Thank you.
I knew you were on it.
All right, Mr. Bloodworth, we're on the record. The jury is not present. Tell me what's up.
Your Honor, the state's waiting on the defense's decision regarding the Norris matter, because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses in the state's case of chief so far, I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to
DC Killing Spree says you can watch police body cam footage of people getting blown away on Kick and not get banned. See, and the Kick show would probably, that I would do, would probably more resemble, like, Kick and Twitch are more set up for just incidental live streaming. Like, you're just live streaming. I feel like YouTube is more set up for having a focused live stream show, like a talk show, like I'm more used to doing. Couple hours, couple, subjects and topics, getting deep into it. I feel like when you're on like Kick and Twitch, like the streamers over there, they tend to just engage their day, their daily content consumption, whatever it is. Some of them play video games. Some of them just like kind of go through Twitter and check out the news and just comment as they go. It doesn't feel as like prepared. It's more just like a hang out with me. And that also, like, I think that has people more free to come and go. And also more, it's more laid back for the streamer. So it'd be a different style of show. And it would be when I don't have something, as focused, to be like, well, I have time that I've been working with Lady Raggets to carve out during the day. So maybe that would be something like that. That's kind of the idea, but I got to check it out. But when a major platform like contacts you and is like, hey, you're partnered, you don't have to do anything, we're going to partner you, then I'm going to give it a shot for fucking sure.
open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of
watch party feature,
Mr. Jeff's statements and, forgive me, the other gentleman,
Bond Savage.
Mr. Bond Savage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay. With the state having rested, Ms. Nestor.
Okay.
Does the defense
State
have
is
a
rested.
We do, Your Honor. Mr. Ramos is going to take care of that.
Okay, Mr. Ramos. Motion for a directed verdict, I'm guessing. Or motion to dismiss effectively.
Your Honor, under both Rule 17-0 as well as 77-1713, discharge for insufficient evidence, the defense presents the following and moves for.
This is what I talked about earlier. Their strategy, and this is kind of it's almost pro forma in a criminal trial, is like, well, the state is done. Now we're going to make a motion to say they didn't do enough of a job, right? Seems like the rational thing to do. And so the judge is going to deny this and say the state did do enough of a job that the jury now has to make its decisions rather than it being resolved as a matter of law. You're now drawing attention to the fact that the state did enough to show that she's a murderer. Subtly, that's a problem when your defense is a non-defense based on the idea that the state didn't do enough. Bad choices. Bad choices. If you're gonna offer no defense, this is a hard motion to bring. It needs to be done just right, and he's already done it wrong, in my opinion.
For a directed verdict. At the conclusion, this is just For the record, Judge, as Your Honor knows, at the conclusion
Hazel
of the
Hadley,
evidence
the
by
only-
the prosecution, which has just been done,
Rumble monetization
the
is
court may
just
issue an order dismissing any
balls.
information or indictment or any count
As
thereof
far as I
on the
can tell.
ground that the evidence is not legally sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficient...
Like, imagine the psychology of saying that. We think some, but not all of the elements have been proven beyond a reasonable doubt. And the judge is going to go, motion denied. The jury now is going to be thinking, yeah, I mean, they did then. Whew.
Sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no
Melody
proof that the signature was
Moore.
done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf
That's true. The jury,
of Eric
the jury isn't
with or
present.
without permission,
You're correct.
it does not, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here. In terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage count 4 insurance fraud is that Ms. Richins, or rather True Stage left a voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured oxy from Ms. Lauber, that while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl. That Mr. Crozier did not provide fentanyl. Rather, he provided prescription grade oxys. From that moment, from the supplier, Mr. Crozier, to Ms. Lauber, the evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl.
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level, non-prescription.
The problem with his argument is that he's relying on a drug dealer selling illicit pills, and the drug dealer's impression of what those pills are is 100% accurate. That's dumb when you consider the fact that the scary part of fentanyl is that a small amount of fentanyl could be lurking in any illicit drug that is used as a filler, and when it hits in a concentration, it kills people. And the people, even dealers, are unaware of this amount, of this amount of fentanyl being present in other things like cocaine or Molly or ketamine. All of these things have had that happen. So this is a shit argument under any circumstance here. Because just because the drug dealer might have been wrong doesn't mean she didn't try to buy pills and load up her husband with an illicit drug and then he died.
Pills were going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer your question.
Okay.
When I do the first show on Kick, there will be significant lead up to it.
Count 3,
locking down the last
as I
bits
understand it, is that Ms. Richins, again according to the criminal information, had indicated a phone number with an incorrect digit. The signature on the application that purported to be Mr. Richins is a forgery. We talked about count 5. And then in the context, and I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect.
Who are the Lost Boys?
I don't believe any evidence has been presented to that degree, or the
P.O. box circumstantial evidence that Eric didn't know about it.
Not necessarily.
JC, normally, I'm with you on this, but the state has closed off any alternative explanation, especially when the defense has said specifically he did not commit suicide. Suicide is not a theory of our case and is not something we're suggesting. So it's either somebody killed him with fentanyl, and she's the one there other than the children. There's no evidence of anyone else. Or he killed himself with fentanyl by accident. There's no evidence in the record that he ever acquired fentanyl, that he would procure it, that he would use it. No containers were found that had fentanyl residue, and he was not. His doctor came in and testified that he was never prescribed fentanyl to the doctor's knowledge and by his medical records. So where's this fentanyl that he accidentally massively overdoses on? Where's that coming from? We don't have text messages. We don't have a transaction. We don't have any shady stuff. But Kouri is buying illegal drugs, according to these drug dealers and her messages. She is buying those illegal drugs. She's asking her boyfriend about those illegal drugs, but she doesn't do them. So the defense theory of the case is fucked.
View the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying
she
that
needed to
Mr. Richins had no
testimony.
idea that P.O. box existed.
An affirmative
There was a
attack
statement
on
and a
these
question
things.
made
saying,
by,
here's
I
how it
believe,
could
the
happen.
state.
They didn't do it.
But no evidence was presented
Or they're not gonna.
to show that was actually the case. That's how I would answer your Honor's question. Also an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric, and was submitted, and was paid from her account, I am not certain that Your Honor could find that term life insurance actually had value.
Wait, what? Because
what I mean
he's
by
overinsured.
that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. So I bring that up. I think that's an interesting point. Obviously, it was marked for $100,000, but the actual value of that, I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew
he's going to do
that she was
colloquy
going
about
to
giving up her rights?
attempt to take her husband's life. And
That'll
I
be
don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, but I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware.
Mere preparation.
In State v. Johnson, 821 P2D 1150.
Yeah, but
that indicates that that is not enough.
If she
Coupled
obtained
with
the fentanyl,
information that we just discussed as to whether it was oxy, whether it was
the
fentanyl,
jury gets to decide whether she
believe
put it
that's
in the drink or
even
not.
Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl, one. Even if it was oxy and she sought to obtain that, beyond that, there's nothing
JC,
else,
the way he's
no
doing
other evidence that
remember,
indicates
all elements
that
of
Ms.
all
Richins
crimes
took those pills,
have to be
the greenish
proved
blue
out.
ones, I think at that time
If he
15
takes
milligrams is what Mr. Crozier
one
said,
element of each
and
one, they win
did
completely.
anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear. In terms of Ms. Richins picking it up, absolutely. That his reaction was a result of that and not anything else, I believe that the evidence is scant.
That's a
Your
yeah,
Honor,
but
question.
No, I'm following.
the problem with what he just said is the evidence is scant that it's that and not something else. Okay, but you just admitted that there is evidence that it's that and not something else. The jury now gets to decide which evidence is correct, which one is the story, which one's the fact.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine.
These are not new glasses, they're
So
old ones.
even in that case, they knew exactly what was obtained. Here, it's
But I don't wear them
unclear
as
what
often.
was obtained.
Just because the color scheme.
I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count one. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
He'll get the last word. Well, no, Judge, you will when you say no. So the state did a good enough job, even if they don't win,
Your Honor,
to
can
pass
I
directed
perhaps
verdict.
begin by asking the court if the court has any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Ramos's argument regarding
Mike,
lack of
what's your
believable
problem with the
evidence
judge?
regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000, well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5, at the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back
Yeah, Boosh, I played
to
both.
Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had,
January 29, 2022, correct?
2022. It was the end of January 2022, at a time when she had already begun asking Hayden Jeffs and Carmen Lauber for drugs of some sort, at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when, she had told Becky Lloyd that she would be better off if Eric was dead, and at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence in the light most favorable to the state that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name.
Hey, TB, I believe, I would assume it was used, sent a Venmo. Very, very nice. Very generous Venmo. Thank you. Says, thank you. You're great. And I'll fight all the assholes. Thank you so much. I really appreciate that.
She had intended the entire fraud scheme that's charged in count 3.
Understood.
Spelling my name wrong for
Anything
years.
further?
Do you do it EI?
Okay. Thank you.
Mr. Ramos, anything further, sir?
Just briefly, and this is, of course, if Mr. Bloodworth wants to respond to this. I did neglect in my argument initially as to count 2 the testimony regarding the, I guess, the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor, heard that, so I would just add that for the record.
Understood.
Thank you.
Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. I appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be in recess until 5 of noon. Thank you.
All right.
Oh, boy. All right, so they've made their motion for a directed verdict. Most criminal trials, that's a thing that happens. It's made. It almost never succeeds. Not going to succeed here. The state has done a sufficient job. Again, you may not think that the state's going to win, and that's okay. That is a perfectly reasonable
Okay.
conclusion.
We're back on the record in case 231-500139. Counsel for the state are present. Counsel for defendant and the defendant are present. The issue before the court is defendant's motion for a directed verdict seeking dismissal of counts 1 through 5 in the operative information. It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial
evidence,
court's
no matter
duty
how
to
slight.
submit the case to the jury.
Because the jury can think that
When
tiny amount
evaluating
of
a motion for
evidence
directed
is sufficient.
verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied. Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor?
No, sir.
All right. We'll be in recess until 1 p.m., just confirming that to the extent the defendant will be putting on evidence or calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time. Court's in recess.
Thank you, Phyllis. I'm about to read you the latest update from that hot new company, IBM. Its young, dashing CEO, Bill motherfucking Gates. Whew. All right, we get to skip all this and see what happens next. There's not much time, not much left. Wait, what? Oh, wait, that was it. That was it. That was my bad. Right? Hold on. That might not be true. So there's going to just be more of day 13. I will find it. I will find it. Fear not. There's just another video. Hold on. Let me just grab it quick. Dirty Sippy Cup says, thank you for the years of entertaining legal education. You are welcome. You are welcome. Okay, here we go. D Sewell 4902. If I remember right, the only thing they found a bunch of fentanyl and they found Seroquel. I think that's about it. I don't think they found anything else. I don't think they found THC, for example. Since this is about to get spicy, I'm going to run to the bathroom real quick. I know that you guys love the Peeing Lawyer song, so let me play it for you. And I'll be right back.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited for what you have for us when you're being is through. When you have a small bladder and no sphincter control, freedom of the liquor doesn't mean freedom from soaking your drawers. Now you're washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, so drink some when the stream is over. When you have a small bladder and no sphincter control, freedom of the liquor doesn't mean freedom from soaking your drawers. drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited. What you have for us when your PM is through. When you have a small bladder and no sphincter control, freedom of liquor doesn't mean freedom from so.
Okay, we are back. Hello. Whew, this stream is lengthy, so let's wrap this up pretty soon here.
Present, Ms. Richins is present. Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yeah, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Can we have just a minute?
Yeah.
We have a couple of options.
Understood.
Diary sits by the bedside table, curtains are closed, cats in the cradle, and who would have thought that a boy like me would come to this?
Your Honor, actually at this time, the defense intends to rest.
Wait, what?
We should probably do that in front of the jury, yes?
Right?
Okay.
I agree.
I just want to make sure.
What would you do
You've
that
consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver of Ms. Richins' right to testify on the record?
Yes. Yes, you can.
Okay.
An insane strategy. The judge has just said there's a sufficient amount of evidence on all counts to at least carry the charge to the jury for a verdict, and they've decided, you know what, we're good. We're good with the introduction of, or with the evidence that's come in. The defense isn't going to, I say this, I can't imagine the defense, and that's wrong too. Hopefully the defense wouldn't be bringing, a copium supply of fucking new evidence for the state. Their theory is if we provide no defense at all, then we will just make the claim that the state hasn't met their burden beyond a reasonable doubt. Maybe you can convince the jury of that in close. But what you're going to have to do is attack the evidence that the state did bring in, because the state's going to make a very compelling case that they have laid out everything. And they're going to probably make a chart as a visual aid. That chart's going to say, here's murder 1. Here's the elements. Here's the evidence. Here's murder 2. And then they'll lay that out, write it out all dramatic, like a teacher, like losing his mind, in like a some khaki pants or something and a short sleeve button up IT guy shirt. And he's sitting there like writing it all out and saying it dramatically as he goes. That Jody Arias's lawyer did that in that doctor killer case. I can't remember, in Colorado or whatever. Have him do that and lay out, line for line, element for matching it to the evidence. And then they turn around and they go, okay, all of this stuff was testified to this date by this person. You can actually review that in your jury packet when you go in the deliberation room and check my work. But now that I've shown you the facts that we have proven out, we've presented them to you, the people who were there, the people who know, have told you what happened in their little bits. Let me tell you what happened to Eric Richins. You have these events, you have them tied to legal requirements, but let me wrap this up in a nice little mini documentary for you and tell you the story of Eric Richins' untimely, unexpected, unnecessary death at the hands of Kouri Richins, the defendant, his wife who was already betraying him, his wife who was already stealing from him, his wife who was constantly complaining about being trapped and stuck, found a way out. She found a way out, but the only one that could get her away from Eric and repair her poor decisions that had put her in so much financial distress that we can't even imagine it. The only way out was for her husband to die, her to collect the insurance, and her to collect that sweet, sweet payout she expected from the years and years of hard work he put into building a business. And he said he'd take care of her. He was going to take care of her until she stole from him, until she lied to him, until she cheated on him. And you just go through it, right? Fucking done. Done. What's the defense going to do? Well, like, maybe that didn't happen. Maybe that didn't happen. Maybe that didn't happen. They haven't built a narrative. If they come in and say, here's the story that we have, right? Here's the story that we have. The jury's going to go, where did anybody talk about any of this stuff? You just came up with a list of things that could have otherwise happened. You just told another story, just a fictional story with facts that aren't there. And then the defense is going to go, reasonable doubt says that this other story could happen. That's reasonable doubt. But the jury's going to be like, but why do we think that other story could happen? No one said any of that stuff did. That's my opinion on basically how closing arguments will go. If like that's how right now, like at this time of night, having watched the trial so far, seeing everything, that's what I would do. Just cement it to the jury. And they wouldn't even get up and defend their client. Don't say that. You'll get in trouble. But you just say, the defense offered no defense because there is no defense. These are the things that happened. We know they happened because the people who did these things told us they did them, including Kouri. And when given the opportunity to tell us a different story, the defense chose not to, hoping that you'll come up with some fantasy and say it could have been that. Well, it could have been a lot of things, but it wasn't. Find her guilty. Grab a microphone from someone and throw it on the ground. And then drop into an Eminem verse. That's what I would do. Kouri's done. Guilty. Out of her mind. Unless the defense has... Like, Ramos better give the best closing argument ever. Like, he better do it with little... Like, in a little... Like, he better rip his fucking suit open, have a Speedo on, be like, whoop, whoop, whoop. Like, he better charm the shit out of that whole Mormon jury. Because he's done. Or they're done. Kouri is toast. Avocado toast. Lemon toast today. I shouldn't say too many food analogies. This one will eat her. Let's see what we got.
You've consulted with Ms. Richins about her, or advised Ms. Richins about...
What kind of appeal can they make when the defense doesn't present a case? Only the objections during the state's case? Yeah. Basically on the judge abusing discretion, on the admission of evidence that shouldn't have come in, that would have prejudiced Kouri an undue amount, and that would be a mistrial. Or, the judge in some way impeding her ability to have a fair trial, but she had all of the confrontation opportunity in the world for the witnesses the state brought. She has the opportunity to call her own witnesses and build her own narrative, and she doesn't. And then right now she's going through a colloquy with the judge where he says, do you understand this? Do you understand this? Do you understand this? Have you consulted your attorneys on this? Is this what you want to do? He's going to eliminate the idea that she's doing this without knowledge. She's done.
Her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you.
That's it. That was it.
Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here for the rest of today?
Sir, let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury. I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin, the parties can work on jury instructions perhaps today or tomorrow. But
Joe, the conventional wisdom says, yeah, you don't have your defendant testify, but you're the only person who knows the story of that night is Kouri. It's the only person, and we're supposed to get it from that notebook that she wrote at some point. She journaled the day of her husband's death. Weird. We're supposed to get it from that and nowhere else? Oh, okay. But that notebook, that yellow notebook, doesn't tell an opposite story. That's the big problem with that notebook, is it doesn't tell a competing narrative. It tells the same narrative. It just doesn't have the words she put fentanyl in his drink in that narrative. It doesn't have those words. But what's the competing part of it? That's the competition. If she just didn't write that fact down, every other piece of the story falls into place exactly the same as what's written down and what the state's going to say. In fact, if I were the state, I might read that thing out and just say, it's just missing a couple details, isn't it? That's what we learned in this trial, that it was just missing a couple details. But, on balance, this journal is correct. This is what happened that night. He did get the ingredients for a Moscow Mule. They were going to celebrate. She just had other plans for how hard he was about to party. Cooked.
then we instruct and close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that.
Sorry, Mr. Miller.
I thought
Wrap it up
we were
soon.
thinking it might make sense to get the jury instruction conference out of the way, and then
I agree with you. May we do it tomorrow? Give the counsel both sides a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
yeah, yes, that's fine.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning. Yes?
Yes.
Yes, sir.
Okay. Okay. All right. Are we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay.
What's up, Mr. Brenman? I do not think the prosecution expected that.
All rise, the jury.
TV says, I'm confused. The dealer said they sold her blues, so oxy. How does that corroborate the fent? Did I miss something? Yeah. Fentanyl is commonly, like most commonly found in where it's not supposed to be. And that testimony was actually elicited by the defense through the lead narcotics investigator. When they asked him about fentanyl, he's like, yeah, illicit fentanyl doesn't show up in doses. Illicit fentanyl shows up in other things, like an oxy pill that was pressed. They had a pill press that was testified to make their own pills. So they get a powder, press it in the pill press. Who knows what's actually in that powder that they got? Stamps it as a blue 30 or whatever. Sure. Or they got corrupted pills. The drug dealer is unreliable, doesn't seem to know much of anything, including whether or not there's fentanyl in the pill he sold, including what pills he was selling in the first place. He never really seemed to know for sure, which means he can't say it definitely wasn't fentanyl, and he didn't. Very, very bad. Okay, here we go.
Please have a seat as you come in.
Yeah, would have been their best defense. It would have, but they didn't, not really capitalizing on it, are they?
Have a seat, thank you. Mr. Bloodworth.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning. I cannot emphasize this enough. Between now and 8:30 a.m. on Monday morning, please do not say anything about this case to anyone. I would understand if you had to tell somebody that you have to be back here at 8:30 a.m. on Monday morning. Other than that circumstance, please do not discuss this case with anyone. Do not allow anyone to attempt to talk to you about it. It will take affirmative effort and diligence. I need you to use that same affirmative effort and diligence
to make
Venmo,
sure you so I am sharing it in both
watching,
chats.
Listening, or reading anything about this case from any source whatsoever. And please do not do any search, research, query, anything of any kind between now and 8:30 a.m. on Monday morning. Please travel safe.
Thanks,
Enjoy your
Fenris.
weekend. I'll see you at 8:30 a.m. on Monday.
How's Johnny
Please rise
Somalia?
to the
I have
chair.
no idea. I don't even really know who he is. legal mindset was covering Johnny Somali very thoroughly.
All right, folks, have a seat. May I propose the following?
No.
That counsel have an email exchange or a phone call, say 4 p.m.-ish today, about the state of the jury instructions and whether you think there need to be any additions or amendments. And then, to the extent there are, please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30?
Do you want to do it a little later just so I have time to look at whatever happens?
You suggest?
Late as possible.
You want to do it at 1?
Yes.
Sure.
Mr. Bloodworth?
Sure. You're like, let us sleep.
So you're all at least going to compare notes by the end of the day today. And if you file anything additional, you'll let me know by email. And I'll plan on being back on the record with you all 1 p.m. tomorrow. Mr. Bloodworth, anything else today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay.
Not
Ms. Richins,
entirely
1
sure
p.m.
when I'll
tomorrow.
start streaming tomorrow.
Court is in recess. Thank you. All rise.
There's plenty to talk about, but I do need some sleep also. It gets kind of short some of these days. How could you have crushed a bunch of blues and put them in his drink? I don't know. I don't know specifically. I believe she may have made the drinks. But we'll see. We'll see. We'll watch their closing argument after jury instructions. Jury instructions tomorrow, closing arguments Monday, and we'll find out what the state is going to say. And then, the jurors will decide. They decide what the facts are. I know, Sheriff of YouTube, I'm just waiting for someone to try and do an illegal sweep, and I can jump kick them all day. All fucking day. Okay. Let me enlarge myself. I think we're about done. I am watching for any last minute Venmos since people were asking about it, but certainly there is no obligation or expectation. I'm just checking to make sure I don't miss before we close out. Could the judge get involved and say there aren't what? Say there aren't what? Yes, TB, I did get yours. Thank you very much. I'd say it was very generous. I appreciate that. It really is wonderful and awesome. Super tip. Here we go. Get that. Oh, we do have a couple of those.
Your Honor, good putang must not go to waste. Allow me to buy her and save the state a burden of having to feed and house as my property. She will be serving sentence until her well dries up, that is.
Sheriff of YouTube says, I am out of here. I just feel super bad for Recta's family. And then says, guy looks like a junkie. Oh my goodness. Not that. How many junkies do you know run around in full suits with, don't answer this, with yellow leather ties wrapped around their head? Come to think of it, probably some. Probably some.
Kouri, don't you remember you told me you love me, baby? You said you'd be coming back this way again, baby. Baby, 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 baby. Oh, baby, I love you micropene.
Psycho Soap, we're right about to go to bed. Just cleaning up the last of any very thoughtful show support that has come in. But guys, the best way you can show support, of course, the show is always free. There's no monetary requirement, even though it's appreciated when people do send stuff. The best way, though, I do ask to burden you with one thing. Please click the like button. Please click that. It helps a ton, both on Rumble and on YouTube. That like button is beautiful. It does help the algorithm know that people watch this stuff, and it does send it to a few more people every time. So I really appreciate it. And of course, if you ever feel like it, really feel like it, you can always click share. That's a great thing. But that's something that's a little bit different. The like button though is please click that and I will love you. Sheriff of YouTube says, bro, I hope you can take a vacation. I did for a year. This life is not worth whatever you're being paid. Sorry, I'm out of here. It's always such a confusing chat. What life? What do they think goes on? Especially when I'm streaming all the time. So right now I wake up and stream, a trial all day. I do some family stuff, and I might do a night stream or go to bed. It's just an 8-hour workday. That's just normal things. I just happen to do it from home, and I happen to do it on this public platform. What eldritch horrors am I facing by doing a YouTube live stream? Live streaming has become a very mainstream profession. I don't get it. But whatever. What do you do all day, sheriff of the internet? You go around policing people. Oh, well, maybe I'm not getting it. Maybe I'm not getting it. Maybe he's just being a sheriff. I'm not sure. My ability to discern things tonight is gone with my ability to remain awake. It's time to get some Z's. I will see you all very, very soon. Oh, wait, here we go. Sheriff of YouTube says, I'm so happy I quit being a YouTuber. The biggest mental cases are in your chat. I thought I recognized your name, Sheriff of YouTube. I know, I've seen your name before. I know that sounds fucking creepy. Let's see. Another super tip. I don't see a sheriff of YouTube channel, so maybe they changed their name. I'm the guy who turned Montegraph into dog meat. Oh, okay. How'd you do that? You're welcome for him being broke. And for the stupid lawyers who took his case on a promise that he'll definitely raise the money or whatever it was. You're welcome for that not working too, I guess. Trying to figure out. I mean, I guess I could click it. I guess I could click on his name, right? Like that. Is that how that works? I forgot. Go to channel. Oh shit, yeah. Well, no wonder you're tired of being a YouTuber. Holy fuck. Guys, let me show you the... They know all about it. Here. Just beg the court's indulgence for just a moment. Share of a YouTube, 2.13 thousand subscribers. We got videos. 2 years ago, you got 160 views, 207 views, 110 views, 68, 130. Guys, reminds me of a scene in, oh, whoops. Let me turn, whoops. In Glengarry Glen Ross. Let's see if, hold on. Let me see if I can find it real quick, just because it's funny. Like he literally did this scene, and it's killing me because it's raw comedy. Oh shit. Always be closing. This is one of the greatest scenes, one of the greatest monologues in movie history, but we're not going to watch all of it. Get copyright claim to hell if we do, but we can see. I'm going by the transcript. I just got to find the one thing. Really? I just gotta find the right spot in the transcript. No. I'm going to find this fucking clip just a second. Glengarry, Glen Ross. It's right at the end of the Alec Baldwin speech. Okay, here we go. Here's a transcript. Here we go. I finally found it. This is, God, like I don't know what I'm doing sometimes. It hurts my feelings. Okay, here. I should just be asleep. You guys do this to me. Here we go.
Guys, gents, the money's out there. You pick it up, it's yours. You don't, I got no sympathy for you. You want to go out on those sits tonight and close?
Close! I got to pause it and add commentary real quick. This is Alec Baldwin, who comes into a real estate investment sales office, basically a scam shop, and he has to give a motivational speech to these salesmen who are having trouble with their numbers. So they have to get first prize in the office, Cadillac Eldorado. Second prize, a set of steak knives. Third prize is you're fired.
Close, it's yours. Not, you're going to be shining my shoes.
Here we go.
And you know what you'll be saying? Bunch of losers sitting around in the bar. Oh, yeah. I used to be a salesman. It's a tough racket.
This Sheriff of YouTube over there right now. He's like, I used to be a YouTuber. God, it was fucking rough. Oh. Man, I hope you found peace. I hope you found peace. I do agree, like, it can be really stressful. It can be tough. It's also been, like, not just monetarily, but, like, in so many other ways, the most rewarding job by a mile that I've could ever imagine.
My name is Corbin Dallas. Your name?
Liluminai lekatariba lamina chai ekbat di sebat.
I agree. Did you just quote Fifth Element? Must have just gone to. Must have just quoted Fifth Element. Like, I can't believe you did that. I thought we were friends. Okay, just checking everything real quick before we close out. Hope you guys have a nice night. Really do appreciate all of you. Even you, Sheriff of YouTube. Again, find some peace, brother. Realize that your experience might be different than other people's. Like, they may look at things with a different perspective than you do. And so the things that you don't like might be things that people thrive on. That's how salesmen are. As one of the worst salesmen in history, trust me, I know. But I worked with some really great salesmen, and watching them thrive in what they did, I didn't understand it, but they still, like, they did it. They made a lot of money. It fed their personalities just perfectly. To each their own. Which means to each of you, your own. Have a good night. Thanks for all the chats. Thanks for all the, the subscriptions and everything else. May you be blessed and have a great sleep. See you in the morning. Peace. Peace.
So pour out an odd bag of Balmore at Lethbrook. Spirits flow as the ones who get unemployed. So pour out a glass for the tea. Post on Twitter as we hear Lost Blaming tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. From the white shores of
Sean McDonald sent in a sticker, but I can't show you. I'll pull it up tomorrow.